signed with them by the appellant right from procurement of wood till finishing of chair. For purchase of wood, the appellant just acted as an agent to buy the wood for and on behalf of AB Chairs Limited, and the wood all along belonged to them, AB Limited, and for their work, only the appellant having no title in such wood. Wood is only in the possession of the job worker, that is we the appellant, CK Trading Limited. The payment made by the appellant was reimbursed exactly by AB Chair Limited, and hence, in the opinion of the appellant acted as a pure agent as per Rule 33 of the DGST Act for the purchase of goods. The counsel further argued that the consumables that were used to finish the chairs are allowed in the process of the job work, and there is nothing wrong. The counsel further argued that the whole adjudication order is based on presumptions and against the fact of the matter, and hence the order has no leg to stand and was legally untenable. My lord, ये मैं इसलिए कह रही हूँ क्योंकि जो हमारा SCN आया उसके अंदर पैरा 1 और पैरा 2 के अंदर, क्योंकि ये SCN आफ्टर अ सर्वे और CK ट्रेडिंग कंपनी का हुआ था और उसके अंदर समन किया गया था AB Chair लिमिटेड को भी, जहाँ वो एग्रीमेंट दिया गया था और वो एक एडमिटेड फैक्ट है और ऑन रिकॉर्ड्स है. नेक्स्ट, the appellate authority was not convinced with the above arguments. Yes.
That agreement, have you placed it on record? The agreement which you talk about, have you placed it on the record?
Yes, sir. This is the this agreement is with the officer.
But you have not filed a copy of that with your appeal.
Sir, I will give.
And what are the materials which were used by the job worker?
Sir, my consumables.
Whom you call job worker? Yes. What was the material which has been?
Sir.
You say only consumables.
Yes, sir.
But probably somewhere the facts say that he had purchased even the fabric.
Yes, sir.
Used for.
Yes, sir.
Now read the definition of job work.
Yes, sir.
And read the definition of manufacture also.
Ji, sir. So definition of job work.
Yes.
Section.
No, job work.
Job work. Section 2, subsection 68. Read as job work means any treatment or process undertaken by a person on goods belonging to another registered person, and the expression job worker shall be constituted accordingly.
And manufacture?
Manufacture. Section 2, subsection 72. Manufacture means processing of raw material or inputs in any manner that results in emergence of a new product having a distinct name, character, and use, and the term manufacturer shall be constituted accordingly.
Yes. Can you say that fabric is only a consumable? Will a chair be complete without the use of a fabric?
Sir, in my case, fabric is consumable.
How? How do you say that?
Sir,
this fabric must have been used with foam on the seat itself.
yes, sir.
Upholstery.
Yes, ma'am.
Upholstery, yes.
Yes, ma'am. Yes, ma'am.
Yes.
Ma'am, the AB Limited has agreed कि उन्होंने बताया कि जो मेरी चेयर्स वो सेल करते हैं उसका प्राइस 7500 है, और जो मेरा बेस्ट जजमेंट असेसमेंट हुआ क्योंकि हम रिकॉर्ड्स नहीं दे पाए थे तो लर्निंग ऑफिसर ने उसको वैल्यूएशन किया 5000 पर चेयर के हिसाब से, और उसी पे उन्होंने हमारा असेसमेंट किया. हमने जो अपना जॉब वर्क चार्ज किया वो 1000 रुपये पर हेड पे किया है. तो जो वो 1000 रुपये पर हेड है उसकी जो बाइफर्गेशन है, कॉस्ट शीट है, वो मैं उसको दे सकती हूँ. और जो हम जब प्रोसेस करते हैं, क्योंकि हमारे GST में प्रोसेस तो कहीं डिफाइन नहीं है सर, तो उसके लिए अगर मैं एक्साइज रिजीम में जाऊँ तो वहाँ सुप्रीम कोर्ट की जजमेंट्स हैं जहाँ प्रोसेस को बताया गया है, और वहाँ पर कुछ जजमेंट्स ये भी कहती हैं कि जो प्रोसेस है जिसको पूरा करने के लिए आप कुछ ऐसे इंग्रेडिएंट्स को यूज़ कर सकते हो जो कि डायरेक्टली आपको प्रोसेस करने के लिए चाहिए. जैसे मेरे केस में जो वुड है, वुड से जब चेयर बनना है तो उसके लिए चेयर एक स्पेसिफिक डिज़ाइनिंग का बनना है जो कि एबी लिमिटेड ने दिया है. उसके अंदर एक तो मेरी चेयर जो है सिंगल सीट चेयर है, और जो वो उस पर कपड़ा लग रहा है सर, वुड जो है एक्सपेंसिव वुड है, मेन जो उसका कॉस्ट है वुड का ही है. मेरे 1000 रुपये में फैब्रिक इंक्लूड है, मेरे 1000 रुपये में थोड़ी सी पैकिंग भी इंक्लूड है जो मैं उसमें दे रही हूँ, प्लस जो मैं पॉलिशिंग कर रही हूँ उस पर, पॉलिशिंग रबिंग, क्योंकि एक लकड़ी का हम पीस जब लेते हैं और उससे हम चेयर बनाते हैं तो वो एक सीरीज ऑफ प्रोसेस है सर।
अब आप ही इसी के ऊपर कहना चाहेंगे कि क्या वुड एंड चेयर आर दिस टू डिफरेंट कमर्शियल कमोडिटीज और दीज आर द सेम?
सर दोनों डिफरेंट हैं।
दोनों डिफरेंट हैं।
हाँ
तो फिर मैन्युफैक्चर की डेफिनेशन क्या कहती है?
सर मैन्युफैक्चर की डेफिनेशन ये कहती है प्रोसेसिंग ऑफ रॉ मटेरियल,
यस,
और
तो यस,
इनपुट्स
यस,
in any manner.
इनपुट्स वुड इंक्लूड वुड बी
Sir,
और
sir,
रॉ
give me a
मटेरियल।
minute.
यस, यस।
सर इनपुट्स की डेफिनेशन हमारे जीएसटी एक्ट में दी हुई है, मैं वो पढ़ना चाहूँगी। सर इनपुट की डेफिनेशन है सेक्शन 2 सेक्शन 59 में। मीन्स की डेफिनेशन है, वो कहती है इनपुट मीन्स एनी गुड्स अदर देन कैपिटल गुड्स यूज्ड और इंटेंडेड टू बी यूज्ड बाय अ सप्लायर इन द कोर्स और फर्दरेंस ऑफ बिजनेस। तो सर मेरे केस में जो वुड आया है वो मेरा इनपुट नहीं है सर, मेरा इनपुट वो कंज्यूमेबल्स है जो मैं अपनी सर्विस, जो जॉब वर्क की सर्विस कर रही हूँ उसको करने के लिए यूज़ कर रही हूँ। और मैं इसको जॉब वर्क की जो सर्विस है, जब मैं सेक्शन 7 रेलवे शेड्यूल 2 एंट्री नंबर 3 को पढ़ती हूँ तो वहाँ बताया गया है कि जब किसी दूसरे के उस पर ट्रीटमेंट किया जाता है, अगर आप कहीं तो मैं सर एक बार उसको भी पढ़ रही हूँ, तो उसको सर्विस कहा जाता है। तो जब शेड्यूल 2 के अंदर सर्विस को और गुड्स को अलग स्पेसिफाई कर दिया है, तो जब मैं किसी के गुड्स पे कोई प्रोसेस या ट्रीटमेंट कर रही हूँ तो उसको बता दिया गया ये सर्विस ही है। और उसको यूज करते हुए अगर मैंने कुछ कंज्यूमेबल्स यूज किए, मतलब जिसके बिना मेरा प्रोसेस हो ही नहीं सकता, एक लकड़ी यहाँ रखी है सर, जैसे मैं इसका ही एग्जाम्पल ले लूँ, ये रखा है, इसको बनाने के लिए जो मुझे सीरीज ऑफ प्रोसेस करने हैं, तो मुझे ये पेंट भी चाहिए, उससे पहले मुझे उस लकड़ी को काटना भी है, तो उस काम को करने के लिए
आपने इस लकड़ी को पोडियम के अंदर कन्वर्ट कर दिया।
हाँ जी सर।
तो मार्केट के अंदर क्या ये लकड़ी माना जाएगा या
सर ये
डिफरेंट
पोडियम माना जाएगा सर। तो सर जो मेरा जीएसटी है,
observed already, there are definition of job work and manufacturing. Both are definition which are restrictive in nature. Job work includes treatment or process. If the legislature intended to include manufacture also, it should have been a part of 268. Now, this definition of job work cannot be read into the definition of manufacture. If we are able to do that, then we will be doing violence to the language given by Parliament. So job work has to be restricted to job work. I am not denying if this wood was not converted into a chair, anything could have been done. As long as in common parlance it is sold as a wood in the market, it's okay. So for example, I give you an example. Suppose you take steel pipes, you do coating on them, is job work, but they still remain pipes. Now supposing somebody gives you milk, I make dahi, it remains milk product, but even their courts have said it becomes distinguishable. It becomes distinguishable.
Different commercial.
Yes. Now here the agreement this appellant had was exclusive agreement with AB Chairs Limited. Okay, we will give you wood, which is Burmese teak wood, and you make chairs. Now, as long as if they had given everything, if they had given fabric, everything, then perhaps it's a labor job. Because the appellant is not putting anything from their pocket. But there also in excise law there are cases, have you converted this to different? But there the appellant says, I have used nothing from me. Now, simply because the appellant says that 1,000 rupees includes everything, it can. Fabric could be 100 rupees, 50 rupees could be formed, 200 rupees polish, she can take back money. But she has to go out of the definition of manufacture. So if we say that this language of job work can be read as a part and parcel of manufacture or the vice versa, that is not what Parliament intended. Now here,
no, it's all right. Yes, what do you have to say in return?
सर मैं ये कहना चाहती हूँ कि जो जॉब वर्क है उसमें और मैन्युफैक्चर में एक जो बहुत बड़ा डिफरेंस है वो ये है कि जॉब वर्क हमेशा प्रिंसिपल के गुड्स पे किया जाता है, वो गुड्स जिनके ऊपर मैं जॉब वर्क कर रही हूँ, ट्रीटमेंट और प्रोसेस कर रही हूँ, वो मेरे गुड्स नहीं हैं। और जो मैन्युफैक्चर है उसके अंदर
नॉट नेसेसरली,
हाँ जी,
नॉट नेसेसरली कोई आदमी मैन्युफैक्चर करता है, हो सकता है जैसे आपने कहा कि बर्मीज वुड क्योंकि एक स्पेशल वुड थी, उन्होंने अपनी तरफ से ये सोचते हुए कि वो घटिया क्वालिटी की यूज़ ना कर ले या एक पर्टिकुलर वो करनी थी, इसलिए उन्होंने वो सप्लाई कर दी। पर उसके बावजूद व्हेन यू ऐड अदर थिंग्स फ्रॉम योर साइड देन इट बिकम्स ए डिफरेंट कमोडिटी।
सर जीएसटी लॉ के अंदर यहाँ ये नहीं कहा गया कि वो कोई डिस्टिंक्ट प्रोडक्ट आना चाहिए जॉब वर्क में।
Judgment we are given.
Yes.
Just one second, just for the audience.
Yes,
Okay, for the audience.
the adjudication order as well as the appellate order, it has been framed under DGST. Whereas in the body of the assessment, he says that this will be termed as interstate. One should determine as
No, but I'm sorry. In Moot Tribunals, we are not taking these technical issues. It's a law only.
This is a law, it's not
No,
a
that's
technical.
okay. We are
Because
not taking
basically,
we are not taking jurisdictional issues on Moot Tribunal. I'm sorry. We are discussing law.
I should say that jurisdictional issue is the first and foremost
But
issue to be
definitely,
raised.
definitely, but not in Moot Tribunal to that extent. We are teaching people what job work is.
Yes,
Huh.
you wanted to read
On that-
read
Yes,
that.
I know that.
On that issue,
Yes,
you are correct.
yes.
Otherwise, it is simple jury.
I know that. Now, my lords, para 20 of this judgment. It is in line with whatever my lords is thinking. On page 22, on
Yes.
top right hand,
Yes.
I'll be reading around 7th line onwards.
Yes.
The word processing herein would mean those processes with the help of hands or machineries connected and linked to the mining activity. It would not include process by which a new or different article other than the one which has been mined is produced. It relates and signifies the composite activity of mining and processing. The intent is not to include processes which would lead to creation of a different commodity as known in the commercial world, for otherwise even manufacturing activity would get covered. Whereas manufacturing unit is liable to pay electricity tariff at a lower rate. The intent and purpose is clearly not to compel and force a manufacturing unit being set up at an acceptable distance from the mine, for the manufacturing unit adjacent to the mine would have to pay electricity tariff. Pertinently, a manufacturing unit set up by another entity, etc. Now, this paragraph will clearly distinguish. Of course, there is the case of DCM, Ujagar paints and excise cases, where, like my lords have observed, if as long as it doesn't result into a different commercial commodity, but in one judgment Supreme Court, prestige case, where Supreme Court says that while giving benefit of job work under excise notification, we don't have that notification in here, okay, court should be slow not to give benefit. But in this case, I think it's very difficult for the revenue to accept this plea that this could be a job work and we should not be taxed. And revenue has taken care to tax only cost 5,000 rupees.
In this case, our opinion is that let the case be set aside, let the assessing authority do a de novo assessment and see, because they have not filed all the materials and documents and agreements also, they have not filed here also. So let him see.
I'm with you. I'm with you.
Thank you.
Favor हुई है रश्मि वैसे? Daily if you go to Okhla, Badali, there's a lot of job work being done. So this case we drafted here to distinguish between job work and manufacturing activity. As long as you do not convert a raw material given by principal into a different commercial product, you may stand covered within definition of job work. So whenever you sign an agreement, be careful you are not converting the inputs, that is goods, given by principal into a different commercial commodity. Right? So it's not your knowledge that counts. Your understanding has no meaning. If it's a technically defined, we are talking of technical product. If it's not defined, we are talking of common parlance. Similarly, she raised a point of being pure agent. No, in this case she was not a pure agent. Rule 33 has some requirements for being a pure agent. You have to be contractually bound. That's why my lord said there is no contract. Right? So when a case is remanded, this can also go deadly against you. So remand is not always beneficial to you. Because when remand is open, then the assessing authority has all the issues. Only when remand is directional, that assessing authority is restricted to the grounds given in remand. So don't accept easily the remand matter. Tomorrow your liability may go 10 times. You never know. So therefore, job work, be careful, and it's a declared service. Job work is a service. It's not a composite service or a mixed supply. It's pure service declared in schedules. So once it's declared a service, you must ensure that you do not end up supplying goods which are differently commodity. So you will be deemed to be a supplier under section 9 and section 15(1) hit you. One point she did not discuss before the Honorable Tribunal. The transaction is between unrelated parties. There is no allegation by the revenue related parties. What is the valuation in section 15(1)? That will rule 28. If we have to deny the job work, then can my tax advice be doubted, which shows valuation? So revenue should have done much more rather than interpreting only this agreement. Because simply job work provision cannot be read to defeat section 15 or rule 28. Rule 28 has valuation rules. Rule 28 to 37, 38, whatever you say. So therefore, as lawyers, we should examine all possibilities where you can attack revenue cases. All points should be taken. But Rashmi has argued, superb. God bless you.
The next case in the causeless list of Diwan Enterprises versus Commissioner DGST, argued by Advocate BP Diwanji, and the case is about Rule 86B.
My lord, I don't have, it can be remanded because he put all the proof.
We are going to ask you have also read this case. Why cost should not be imposed
On revenue, yeah.
getting officer as well as the first appellate authority.
So we are imposing.
Not revenue concern.
Yes, we are not on the housing, we are imposing cost of this 5,000 each to be recovered from their salary from the assessing officer, adjudicating officer as well as the first appellate authority. Because they just read only the 86B. What about the proviso? Is it not a part of that section 86B? He should have read proviso of 86B.
No, he should have read, but there were no documents placed by them.
He could have, from the system he could have seen.
No, from system it cannot be seen.
He could not replicate his liability. No.
Mr. Counsel,
Before issuing the notice, he should have seen.
the portal which is available with them, they can see income tax documents also. So 26AS is available. They can see from that whether the person is filing income tax returns or whether he is depositing income tax. So from that, they could have seen that the tax more than 1 lakh rupees has already been deposited continuously 2 years.
No, but my lord, the question is, if this is the duty being cast upon revenue, there should be a provision. The Income Tax Act has not been incorporated by reference here. No, my lord, one second. Even income tax balance sheets are not acceptable to GST law. So where is the question of they going to portal? Do you think all these also will start?
It was just a question of fact whether they have deposited more than 1 lakh.
No, but once the man doesn't come for any reply, what does revenue do?
They have deposited.
If all cases are ex parte below. Ex parte, so my lord, you can say for their own negligence, they should be given premium.
No, we are not giving any premium. We are seeing the negligence of the officer concerned. he has passed this order as if he is punishing them.
No, he's not punishing them. He's asked for reply. No reply was filed. No reply was filed.
Appellate authority is also supposed to know something. He's
No, there's
also
no person supposed
he's
to
a
know.
higher
What is
officer
the
than him.
requirement? It is whose case is this? Appellant's case. He doesn't do anything to put the burden on appellate authority.
For minor default on the part of the dealers, you are punishing them.
My lord,
with,
we know
with
all
heavy,
74 cases. All showcase notice are basically fraud. Has High Court punished any revenue officer?
He failed to appear for one reason or the other. It does not mean that he should have.
No, but he doesn't appear anywhere.
He had not committed any offense.
He doesn't appear.
A person
As long as appeal being accepted at this stage, I have no objection.
These costs are to be recovered from the salaries of those.
आप हंस रहे हो, आपके salary से जा रहे हैं, मेरी salary समझ जा रहे हैं।
Sir, let me state one thing. When
हाँ
there
जी।
is specific provision in the 86B for the exceptions, if he is filing the income tax return, so the revenue officer he should have seen this thing. Na? It's a very important thing. How can he cancel the registration retrospectively? This is not understandable.
Should I say something?
The registration should be restored immediately.
Yeah. Wait, thank you.
I have been called by the High Court. I don't know why. Maybe for some administrative reason. So therefore, I am just these two of my friends. They would be hearing the other matters.
So thank you for your time. आइए खन्ना साहब, आप अपनी पोजीशन लीजिए ना, आइए ऊपर आइए। आइए आइए। Well, friend, Rule 86B is a serious rule. It is a self-contained code. Which says if your turnover per month is above 50 lakh or whatever the limit, you must deposit 1% in cash, notwithstanding what input as credit appears your electronic credit ledger. The proviso gives an exception. 1 lakh rupees income tax, director, whatever it is. Right? So if you get a notice, you must file a reply. I don't have any view on this case. They should show income tax record of people with PAN number. No, I don't think anybody will say. I don't think there is any duty cast upon you. But if the Honorable Tribunal thinks, why were they serious? Because the revenue cancelled their RC retrospectively on this lapse. Retrospectively. And the fact is, the appellant was very negligent. He did not come. Now supposing by the time you come to tribunal, it takes 6, 7, 8 months. The client is already finished. He can't do anything. Therefore, do not be careless. I always maintain as a lawyer, even if a peon from department sends a notice, must file reply. Supreme Court will not pardon you if you take officers for granted. Don't say मैं उनको मिला आया था, मैं उनको बोला आया था कल आऊँगा. There is no record कि जो कल आओगे जो हमको कोई वीडियो नहीं करे आपने मिलके आए थे. So Rule 86B is a serious violation courts have held, and your RC can be cancelled retrospectively. So now see, he has come to tribunal. He did not apply the showcase notice, adjudication order ex parte, appeal ex parte. So now by maybe 6, 7, 8 months he has come to tribunal. So what happened to his client? What kind of litigation they would already have with the buyer and seller? सबका IT से रुक जाएगा. Therefore, notwithstanding the strict legal position what Honorable Bench is stating to us, we should be careful to file reply and ensure this matter is not aggravated further. Right? Okay.
Friends, sorry for the interruption. We have CA Sanjam Agarwal ji from member NIRC. We welcome him.
Let's welcome him. Thank you, sir. Thank you.
And the court is resumed. Registrar.
The next case of the causeless is of Ankit Manufacturing Commissioner DGST that will be argued by CA Ankit Mittal. And the case is about block trading.
Go for it. मेरे notes.
For starting your argument,
Have you gone through Rule 33 of the procedural rules?
Trust. Okay.
Whom you have made the respondent?
Respondent is the commissioner, assistant commissioner.
Your appeal does not say so.
It should be only commissioner, not joint.
You have said it joint commissioner. It can't be joint commissioner. Whenever you make a respondent, it's only the commissioner. Maybe you have in your mind that you want to make another respondent or any other officer as a respondent. You have to move an application before the Honorable Tribunal requesting that I want to implement so and so as another respondent number 2 or respondent number 3. You have not deposited, you have not enclosed challan for miscellaneous application.
So I do, I submitted, maybe it got misplaced. I do have that in my file.
You should have enclosed it before filing an appeal.
Yes, sir, I have
You should
enclosed
go
it.
through
Maybe
it.
it got misplaced, but it is already paid and I do have a copy of that.
Secondly, you have not
Good.
mentioned any reason why you are filing the application for the additional evidence.
That is itself the part of the application, ma'am.
This is a part of the
It
application.
is there. I think it's given this part 2. In this, everything is there. I have.
This is not
Part 2 सबको नहीं दिया आपने?
Sir, all the copies was sent, sir. Maybe.
Secondly, you see page number 3 of your application, miscellaneous application. Supporting affidavit. Is it there?
Yes, sir.
Supporting affidavit. Is it a mockery of an affidavit? What is it? Rule 78 specifically mentions how an affidavit is to be drafted and enclosed with an appeal. 78 of procedural rules.
I'll go through it, sir. I'm sorry, maybe I missed that. So next time, definitely, I'll keep it in mind.
And more so, it should have been on a single paper. You are enclosing it as if it is a rough paper filed before some lower authority or somebody else.
Which one, sir?
See, you see your page 3 of your miscellaneous application.
So I.
And you have to be careful in future.
I need to understand, sir, what is the mistake actually. I am
Doesn't matter. Be careful. That's all.
Mistake is that there is a proper format.
Format, okay. Okay.
So you have to use that format.
Okay.
You can't just do off your own.
Okay. Okay. I missed, sir. I missed that. I'll keep it that mind.
Lesson is whenever punch says something, never argue back. Okay? तो हमारे पे कॉल लगा रहे थे माफी मांग के हमने कॉल बचवा दी.
Why should I allow you to argue this case?
Sir,
Why should I allow?
Sir, just power of attorney has been submitted, sir.
Yes, you see your power.
This is how you learn.
सर ने भी नहीं देखा है मुझे लगता है.
मैं तो पहली आज ही मिली है. पहली आज मिली है मैं क्या करूं?
Stamp you have not put here.
Okay. Authorized person with seal. The signature of the authorized person with seal is missing.
Yes.
What is it?
So unless somebody authorizes you, how can you argue?
And stamp part is also missing.
Make a note of all this.
Yes.
Take care in future.
Noted, sir. Well noted. Thank you so much.
And
Okay,
this can be
proceed.
cost you have to pay to DGST on this issue. Otherwise, I will object.
We have not announced the judgment.
These adverse observations are very well taken, but let's not try to suffer him just because of the technicality and hear the case at least on merit.
Yes.
If my friend,
Because the audience they have to know. Care is to be taken before filing of.
And it's for the entire audience, these lessons, not for you alone.
Thank you so much, sir, for sharing.
Actually, ये फायरिंग मेरे को कर रहे हैं, आप मेरे को नहीं, आप नहीं मेरे को कर रहे हो कि मैंने नहीं देखी चीजें.
merit पे आया.
morning to all of you. I would like to proceed with your kind permission. So the case in front of you, the question of law is, it's related to section 17 subsection 5 clause D, whether a steel created a shed made by a steel assembled on a 6 feet cemented wall can be considered as immovable property. The fact of the case are, the appellant Ankit manufacturer registered under GST under the DVAT Act, Delhi GST Act, engaged in the manufacturing of hydraulic pump. A show cause notice dated 12th October 2025 was received to the assessee stating that an ineligible input tax credit over a purchase of cement and steel was taken, where the appellant is a manufacturer of a hydraulic pump. The officer alleged that the steel and the cement used in the construction of an immovable property. The appellant duly filed a reply and stated that this shed is used for the betterment of the functioning of the machinery without considering the facts. The proper officer did not appreciate it and issued an order against to the assessee. Agreed to this order, assessee filed an appeal under section 107, but the appellate authority as well did not appreciate the facts. So from the parties agreed from this order, and before you for the considering the facts, so I would like to share a ground of appeal. So first ground of appeal is officer did not examine the true nature of the asset, why it was constructed. The shed was placed there to protect the machinery, to make more stable, to increase the efficiency of the machinery and the life of the machinery, rather enjoying the shed as immovable property. Under the Safari Retreat case, the Honorable Supreme Court held that we need to examine the nature of the asset by applying the functionality test. What is the true function of the asset? In each case, on its own facts, we need to examine. So where in our case, the shed was not at all relevant and required if there is no machinery. That means it is directly related to the functioning of the machinery. It becomes internal part of that. Further, the second ground I am stating here is to make ITC ineligible, the property must be immovable. But in our case, the shed can be easily dismantled and moved to anywhere and even be sold as it is. That means the functionality, the two tests like marketing test and the movability test we are fulfilling here. I would like to highlight another case in the Bharti Airtel Limited versus Commissioner, Delhi High Court case. Under this judgment, the matter was involved regarding the telecom tower. And that question of law was whether it is an immovable property, the telecom tower itself. The court held that the telecom tower is fixed, yes, by creating a cemented structure, but fixed by using bolt that can be dismantled and that can be moved anywhere, and that also can be sold as it is. So I believe my case facts are similar to this case law, and as per this ruling, which is binding to this court as well, I believe, so are similar to my facts, and my construction of this shed should be considered as a movable property. So I rest my case with your wisdom, sir. So further, I would like to highlight that kindly that the few evidences we have We are few evidences we unable to submit before the appellate authority, so we submitted a miscellaneous application before you. Kindly consider the same as well. And my prayer is, sir, kindly consider this shed as a movable property. ITC must be allowed, and order should be quashed. Thank you so much. Right, sir.
Yes, sir.
Well, my lord, this question is where ITC is blocked. When we read section 16.1, it says a registered taxpayer can have ITC or blah blah blah, subject to rules that may be prescribed or as may be prescribed. Section 16 is not a self-contained code in GST mechanism. It is subject to section 17 or other provisions where ITC is restricted. 17.5 deals with such cases. There are two clauses that restrict input tax credit. My lord, I would like to read it. 17.5C and D. Notwithstanding the judgment my friend has quoted, we still have to appreciate the law. 17.5 starts with a non-obstante clause, notwithstanding anything contained in subsection 1 of section 16.1. So 16.1 says you can have input tax credit if you receive goods or services or both from a registered supplier, which are to be used in the course, used or intended to be used in the course of furtherance of your business, right? So if 17 was not there, you are entitled to ITC without any restriction, right? So section 17 starts with notwithstanding anything contained in section 16.1. So this creates an exception to section 16.1. कभी ये काम करते हो तो आपको ITC नहीं मिलता, right? So when we go to 17.5, Your Honor, input tax credit shall not be available. The word used is shall not, may not. Shall not, so it's a very imperative language used. Then we come to 5, I will go straight away there. C and D. Works contract service when supplied for construction of an immovable other than plant and machinery. That is the exception they create here, except where it is an input service for further supply of works contract. So they say if you construct an immovable property, which is the only definition of works contract in section 2 within bracket 119. You must note and read this definition if you want to appreciate this provision better. Immovable property other than plant and machinery. Now when you read this word immovable and within bracket they create an exception, plant and machinery, so they don't care whether it's plant and machinery movable or immovable, as long as you can categorize this as plant and machinery, except where it is an input service. So if you are a subcontractor giving a service to a principal contractor, then you are entitled to get all input tax credit. But the employer will not get input tax credit. When you buy whatever you buy to construct that, you can get. Then come D, goods or services. Now C was referring to only works contract. D has bifurcated all this into different categories. It says goods or services or both received by taxable person, not registered person, taxable person, right? It has a huge implication in law. 16.4 is applicable to registered taxpayers, the limitation. But once you come here being a taxable person, so even if you give me a showcase notice 3 years, if I have a tax on my assets, I will claim input tax credit. I'll fight it out. Because 16.4 I'm out of it. That deals with only registered taxpayers. I think you will know, appreciate better. So goods or services or both received by a taxable person for construction of an immovable property other than plant and machinery. It was earlier plant or machinery. Now they have amended after safari retreat to be plant and machinery on his own account. So he is building his shed on his own account. right? On his own account, including when such goods or services or both are used in the course of furtherance of business. So if he is buying cement, steel, engaging labor to create this 6 feet cemented wall and a shed on this, right? This is also, he may be making it, using it for making taxable supplies. Even then there is a bar. Okay, input as credit cannot be given to you. Now there is an explanation. This explanation created a lot of problem in Safari and Bharati retreat. For the purposes of clause C and D, the expression construction includes reconstruction, renovation, additions or alterations or repairs to the extent of capitalization to the saddable property. Expression 2 for subclause D, which we are referring, it is hereby clarified that notwithstanding anything to the contrary contained in any judgment, decree or order of any court, tribunal or other authority or reference to plant and machinery shall be construed and shall always be deemed to have been construed as reference to plant and machinery. This was the retrospective amendment after Safari retreat. Now the case is whether this shed being made on a 6 feet, not 4 feet or 2 feet, 6 feet half wall, and then they create a shed on this. Can we say this is immovable or movable? Now if you twist the facts, let us say this shed was, like I said, is not with nut and bolt. It can be dismantled, taken anywhere. Supposing you were putting a hole in the wall and putting a saria there, then creating a structure which is permanent. Right? Now can we say it will make it immovable? The answer is no. I'm going little different from his case. I'll case this case come later. So can we say this becomes immovable? Supposing the legs of the shed can be cut and taken anywhere. Let us say you make a shed with prefabricated walls. Can we say this is immovable? So when the concept of immovability comes in indirect tax regime, when term is not defined, you have to see what is the function of the asset being created. Supposing I make this Malvi Southern building. We are making with cement, steel and concrete. Supposing I make it with fabricated walls, prefabricated walls. This will never be movable. Notwithstanding, I want to use it for 40 years. Because I can remove prefabricated walls and keep it anywhere. If you go to China, they make hotel in 20-30 days. How? They are using those prefabricated walls and make hotel, they convert. In fact, they move the hotel itself on the machines. America में बहुत सारे मंदिर move हुए हैं. Whole building. Right? So whenever as professionals we are faced with the situation of movability or immovability, you have to be very careful what is the function of this asset. Safari retreat and Bharatiya HL, they are two different judgments. They have no similarity whatsoever. Please remember, Safari retreat was dealing with basically the challenge to constitutional virus, whether you can deny input tax credit when property is immovable. So Safari was not dealing with movable property at all. They laid down a functionality test to know whether the asset you are creating, can it be plant or machinery. On that premise, after examining all income tax judgments of Supreme Court, what is plant, what is not plant, they said income tax judgments are irrelevant for the purpose of GST regime, because the scheme of income tax is totally different. So, in income tax, if you see Taj Mahal Hotel, even the tutis were held as plants of the hotel. The washroom tutis, whatever you call them in English, and taps, right? In income tax, there is a cinema theatre is a plant. But they said no, these judgments are not relevant for the purpose of GST regime, because the taxability and the scheme and the purpose of the act is totally different. But they came out with two theories. One theory was functionality test. What is the function of this asset? Then they said, if this asset is not immovable, can this be a plant for the purpose of your business? So there was, the petitioner was creating a shopping mall, which right from day one, he was supposed to be giving on rent. He says once he is willing to pay rent, he is paying a taxable supply, Why should you not give him input tax credit? That was the challenge in Safari retreat. But after judgment came and most of us thought that the input tax credit has been given. But Supreme Court did not decide this issue at all. They gave guidelines, they remanded the matter. But here came Parliament, they retrospectively amended the definition, and instead of plant or machinery, they held plant and machinery. Right? Lot of research has been done, hundreds of articles have been written by very learned lawyers. Most of us think this retrospective amendment makes no difference. These two tests still remain, functionality test and whether it's a plant or not. But the question is, if pursuant to a judgment, the judgment has been nullified by Parliament, can we say any test can remain? That is the function of Article 141. Supreme Court declared a law, Parliament said, no, we don't agree. Your judgment is not good. We will lose lakhs of crores of rupees. That is why this amendment has been challenged in various high courts, including Supreme Court, whether this retrospective amendment could be done. When this case came in Bharti Airtel, which my friend is referring, and rightly so, there was an earlier case in excise in the same case by Bombay High Court. There also they held on similar lines. Now, before Delhi High Court a point was taken, they said the telecom towers are in exception category, we will not deal with this at all. But High Court said we are not dealing with this. We are dealing with whether this asset is movable or not movable. So based on facts of those telecom towers case, which were again put on a concrete bed of 3 or 4 feet, and then they put tower. They demonstrated, which my friend has failed to demonstrate here, they demonstrated that we nut bolt, we can open it, take it anywhere we want. It's a question of 2-3 hours job. And they could show in the court that these are assets which can be displaced only when we unscrew the nut and bolts. Bharti Airtel did not refer Safari at all. For the simple reason, Safari was not to be referred here at all. But the concept was is movable or immovable. Therefore, in Bharti Airtel case, Safari retreat was not discussed. So like my friend's case, he said there's a 6 feet wall, on this I have created a shed of whatever height. Now which he's argued this point, rightly so, you are not creating this shed for the taking benefit of this shed. You are creating this shed so that your machinery which is placed below the shed can work efficiently. If you go back, remember जब कंप्यूटर आए थे, सर ये AC रूम में रखना है, पता नहीं क्यों रखना था, हमें पता नहीं था, हम सबने AC लगवाए थे, हाँ वो टेम्परेचर जो भी बोलते थे. Now supposing the same case was there today, could we say AC is not a part of plant and machinery? Without AC you cannot run computers. Let us say telecom tower uses lakhs of liters for diesel to create the power to transmit connections. It was held that diesel can be purchased against C forms for telecom towers. It was allowed for the simple reason that this is a test of functionality. Right? Now what my friend has argued, 80% rightly argued, but he has failed to demonstrate how was the shed, what were the photos, what was the contract he has filed. It has some clauses like this. You should have referred to contract in detail.
He has enclosed the photo.
I know.
आपने तो रेवेन्यू का आर्गुमेंट कम दिया और अपीलेट का ज्यादा दे दी.
तो सर हमने केस समझ पैसे तो नहीं मिल रहे मेरे को. ये तो मेरे क्लाइंट तो ये है सर जी बैठे हैं. मेरे क्लाइंट ये हैं. They should go back thinking, and now they know the difference between safari and retreat. Now my friend has enclosed photos. Okay, what is the shed about? But again, he should have enclosed further document. What is the machinery there? How will the shed help improve its function? You get my point? यदि बरसात है खराब होएगा, मौसम है खराब हो जाएगा, तो there should have been much more technical literature with this also. Getting a remand, this is okay. But when you go back, नीचे अगर वो अफसर काबिल है, ये दिनेश चाहता को होगा तो ये तो गूगल करके सब कुछ निकाल लेगा क्या क्या चाहिए वहां पर। नहीं, ऐसी बात नहीं। I had done with a case with him, sorry to go. It was on warranty charges of 3 biggest car distributors of NCR. तब इनसे मेरी दोस्ती नहीं थी. He grilled me. ये नोटिस वो नोटिस पता नहीं. We replied.
हम तो पहले डरते थे इनके पास.
अकरम की मोहम्मद अकबर की जजमेंट अभी नई आई थी, which in my view was not applicable to our case. But he gave relief, passed a 75-page assessment order on warranty issue because the amount were huge. मतलब इतने सारे तो डॉक्यूमेंट दिए थे, कंपनी ने क्या किया, आपने क्या किया, कॉरेस्पोंडेंस क्या हुआ, ये बकवास सारा कुछ ताकि रेफरी नहीं हो. So this is where Ankit's case is कि if my shed with walls is held to be movable, should I not be given input tax credit? So since the Bharatiya Airtel judgment of Delhi High Court, there is no contrary judgment of any other High Court or Supreme Court. So revenue should fairly concede in the hands of tribunal. Whatever they do, will act.
I think Verma sir has already explained my case.
What you had to say, he has said it.
So I would like to submit yes that I stated that my shed was definitely just created to well functioning of my machinery.
You said so.
Yes. So that's all what I wanted to say, and that yes, the 6-feet wall was definitely important because my machine size is very huge.
Yes.
So that's why maybe I did not.
It is
mention
typically,
earlier.
you should have.
Yes, this is a new point. This you should have said earlier.
ये फोटोग्राफ आपको दिखानी चाहिए थी.
Should have displaced.
Okay.
You have given just this one photograph.
Even otherwise, the explanation to section 17.5 very clearly says that for the purpose of this chapter and chapter 6, expression plant and machinery means apparatus, equipment, machinery fixed to earth by foundation or structural support which are used for making outward supply. So this shed what we find is used for making outward supply. To that extent, I think we should rather allow rather than
We will not remand it. Your appeal, we accept your appeal.
Your approval.
The ITC should be allowed.
50,000 पे DGS को जमा करा देना, क्योंकि ये आपकी जिंदगी भर की कमाई दी है आपको भाई, तो यहाँ ये बेचारे खाली दोनों घूम रहेंगे. नहीं, I mean it serious. But don't say कि tomorrow मैंने आप अदा कर रहे थे.
Okay, next case in the causeless today is of Himanshu Real Estate versus Delhi Commissioner DGST, argued by CA Himanshu Singhal, Advocate Himanshu Singhal, sorry. And the case is about transfer and assignment of leasehold rights, applicability of GST on the same.
Himanshu is from Roper, Hapur. He is come from Hapur to argue this matter, and he has worked very hard on his appeal.
Again, Himanshu, one point. Earlier said, you have not seen the procedural rules. Appeal cannot be against Joint Commissioner.
अच्छा APL 5 में भी कहीं आपकी गलती है, आपने ठीक से नहीं भरा उसको.
अपील में वो जॉइंट कमिश्नर ही आपने लिखा हुआ है.
कमिश्नर DGST.
APL 5 में लिखा है करेक्ट, लेकिन अंदर उसमें वो नहीं लिखा हुआ है.
इंटरेस्ट की उसमें इंटरेस्ट नहीं लिखा है आपने. एनीवेज अच्छा, आपने इसमें एक और गलती करी है. यहाँ पर आपने जैसे द ऑनरेबल जुडिशियल मेंबर एंड हिज कन्वीनियंट जजेस उल्टा लिख दिया गलती से. वो थोड़ा देख लेना. बैकग्राउंड ऑफ द केस की जगह स्टेटमेंट ऑफ फैक्ट्स इज द बेटर वन.
Proceed.
Please proceed.
Good morning to all. The case of Himanshu Real Estate Developers Private Limited.
I click कर दूँ.
In my case, my client are assigned a land to XYZ Limited. The department doing the scrutiny of the case and getting the statement amount of rupees 20 crore received in a bank statement. The department levy the tax of rupees 3.6 crore and interest of rupees 56 lakh. The department have no any evidence that this is the lease or lease of land. Are firstly when the I replied first against the SCN, then the council given the
Mr. Counsel, you can proceed in any language which is comfortable to you.
Thank you.
Yeah, please.
अभी जो SCN फर्स्ट आया था तो उसमें काउंसिल ने जो अपना रिप्लाई दिया था डिपार्टमेंट को, तो उसमें उन्होंने बताया कि हमारा असाइनमेंट है, पर डिपार्टमेंट ने उसे नहीं माना. डिपार्टमेंट ने ये 20 करोड़ की जो रिसीप्ट है उसके ऊपर टैक्स लेवी कर दिया पूरा से. और डिपार्टमेंट के पास तब की कोई एग्रीमेंट भी नहीं था, कोई डॉक्यूमेंट्री एविडेंस नहीं था. उसमें भी आफ्टर दैट डिपार्टमेंट लेवी ऑन द टैक्स. My case ground of appeal है जो हमारी ट्रांजैक्शन है वो सेक्शन 7 शेड्यूल 3 में आती है, जिसके अंदर वो ना तो सप्लाई में आती है, ना सप्लाई ऑफ गुड्स है, ना सप्लाई ऑफ सर्विस है. और इट्स ए लॉन्ग टर्म लीज राइट्स आर बेनिफिट अराइजिंग आउट ऑफ लैंड ओनली. वी आर नॉट ट्रांसफर द राइट टू द right of our land to the XYZ Limited, but just we are leasing our land to the XYZ Limited. इसी एक केस अभी गुजरात हाई कोर्ट में आया है, गुजरात चैम्बर ऑफ कॉमर्स का. उसमें गुजरात हाई कोर्ट ने फेवर में क्लाइंट के दिया है कि उन्होंने गुजरात हाई कोर्ट ने माना है कि सेक्शन 7 शेड्यूल 3 के अनुसार जो ना ये ना सप्लाई में आएगा, ना गुड्स सप्लाई ऑफ गुड्स है, ना सप्लाई ऑफ सर्विस है. सो इस पर GST लेवी नहीं हो सकती है.
इसका कोई पर्टिकुलर पैराग्राफ आप पढ़ के बताना चाहेंगे?
जी.
ये लीज जो है, इज दिस लीज फॉर अ शॉर्टर पीरियड और अ लॉन्ग
सर,
पीरियड?
दिस इज नॉट अ लीज, दिस इज असाइनमेंट.
Assignment.
Lease as vis-a-vis assignment. So this document is for a limited period or for a broader period, longer period?
So with a longer period.
But you have not mentioned anything.
I might mention.
कहीं पर भी नहीं आपने लिखा.
Okay, this is for the longer period. Though you are mentioning in your judgment that this is for the 99 years lease in that judgment, but in your grounds or in your other things you have not mentioned this fact.
Yes, go ahead with the judgment.
जजमेंट के पैरा नंबर 67 में लिखा है.
पेज बताइए.
दो 280 पेज की जजमेंट है, दिमाग खराब कर दिया है.
It is followed by Bombay High Court.
Yes.
That's another longer judgment.
A lot of law has been.
Page number 32, para number 32.
Along page 8, he has mentioned lease is for 95 years. Page 8. Professor B. No, I think referring, I'm sorry, he's referring Bombay High Court. Okay, sorry.
However, when such leasehold right is transferred by the lessee assigner in favor of a third person, assignee by execution of deed of assignment, it would be nothing but transfer of an immovable property in relation of land and building and includes a lease. The consideration therefore as premium, one-time premium, is a measure on which tax is to be levied, assessed and recovered. Therefore, when the GIDC allows the plot of land of lease of 99 years and charges premium for such allotment, followed by the periodical lease rent to be paid, is to be considered as a supply of service in relation to land and building. Read clause 5. Sorry, 32 page judgment में लिखा हुआ है. पैरा नंबर 63. When such leasehold right is transferred by the lessee assigner in favor of third person assigned by execution of deed of assignment, it would be nothing but transfer of an immovable property in view of in relation to land and building and include a lease. The consideration therefore as premium, one-time premium, is a measure on which tax is to be levied, assessed and recovered. Therefore, when the GIDC allowed the plot of land on lease of 99 years and charges premium for the such allotment, followed by periodical lease rent to be paid, is to be considered as supply of service in relation to land and building. Read with clause 5 of schedule 3, which specifically provides that renting of immovable property shall be treated as supply of service. यदि मैं शेड्यूल सेकंड में आएगा तब उसके अंदर लीज मानी जाएगी, लेकिन जो हमारा असाइनमेंट है वो शेड्यूल थर्ड में आ रहा है, इसीलिए हमने उस असाइनमेंट में जीएसटी उस पर नहीं लगेगा.
आपके इलाहाबाद हाईकोर्ट की भी एक जजमेंट है, राजीव कुमार एंड अदर्स वर्सेस टेकन 2017 की जजमेंट है जो आपके फाइल कर. यस सर.
My lord, the question we are arguing before the tribunal is whether a judgment of Gujarat High Court, Bombay High Court is binding on us by any stretch of imagination. It may have a persuasive value. More so when matter is pending in Supreme Court. All three cases, including Alpha's case, are pending in Supreme Court. There is no stay given by Supreme Court against the judgment or any other direction. Our view is it's covered by Section 7 supply, read with Section 9 and schedule. It is a taxable transaction. The assumption on which those high courts worked was their lease was for 90 years plus, and those lease had a right to mortgage, to sell, to transfer, to assign. Based on these few parameters, High Court said that these are rights of ownership. 95 years, a person's 2 lifetimes. So they said this is nothing but a sale of land. Therefore, where is the person of service? And therefore, no GST. In GST law, we do not have such provisions. This could be the interpretation of a particular high court, a particular bench. If you go back into land, Your Honor, there are a number of rights given by land. First is when you buy the land originally. Let us say I go to DSIDC, buy a land. This cannot be taxed. Now this land, I construct my factory, no tax. This land I give on rent, situation changes. I create a building, give on rent, situation changes. The land remains same, right? Or let us say I give to a builder in terms of TDR, it is 18% taxable. I sublease, it is taxable. So what happens when I do assignment of a lease rate? Assignment is for a consideration. The transferee, the assignee doesn't become owner of the land. For 95 years, he gets a right to use this land. So to say that we are not covered by definition of supply based on these 2-3 High Court judgments, including Allahabad was little shorter judgment, these are bigger judgments. Rajiv Agarwal judgment are very small. So to say on base those High Courts is a different matter. But even Gujarat High Court, and which was followed by Bombay High Court. Bombay High Court judgment was purely Gujarat High Court judgment. They copied it and said endorsed. So once its matter is pending in Supreme Court, there is no way we can allow exemption. Therefore, notice under section 74 is valid. We are going to tax them with interest penalty. They have to take a chance. Tomorrow, if we don't tax them today, tomorrow Supreme Court says it's taxable. So revenue cases go for a 6. They become a time bar. After Supreme Court judgment, it's not a ground for reopening a case. Therefore, this notice was validly issued. Notwithstanding, there are 2 judgments or 3 judgments or 4 judgments against us, but those judgments are not Article 141 judgments. Under no constitutional scheme, those judgments are binding upon me.
But Your Honor, since the GST scheme is central scheme, it's a central tax, central act as well. Once any judgment passed by any high court, right, like in the income tax, that's binding on anywhere in India.
No, Your Honor, I disagree. There was one judgment of Kusum in court, where lot of people scored. That judgment is totally irrelevant. There, some law was declared unconstitutional. There I agree with my lords, if a law is a circular notice declared ultra-virus or illegal, it's applicable all across the country.
Had the Supreme Court stayed the judgment, then we would say that it's not
But that doesn't matter. What I'm saying is, we are taxing them. You can keep the recovery in arrears till Supreme Court judgment. We have no issues.
Yes,
We have no issues. But there are no documents annexed whether they fall into paramaterial facts of Gujarat High Court or Bombay High Court. There is nothing on record as such.
So far as this judgment is concerned, they have worked so hard.
That doesn't matter. How does it matter?
But they have laid a law. They have laid a principle.
No, my lord. That principle is based on MSIDC lease deed. Lease deed. We don't know what is this lease deed.
Because this falls in the jurisdiction of the UP. Even the UP High Court has also allowed.
No, but that's again based on a lease deed by UPSIDC. There is no document here. Let them produce a document. We have no objection. Let them debate it before lower authorities. And if tax is levied, we will keep the recovery in abeyance till Supreme Court decision. That's the favor we can show to them.
That can be done.
Yeah, please wish. No. I've gone through. Yes, sir.
Do you find any judgment of any high court who shows the revenue on this particular?
No.
Then whatever happens, say, assuming, so far we are still in the process of discussing amongst ourselves, assuming that we decide this issue in favor of the appellant, then department can also go in for an appeal, and then whatever happens up to the...
I'm raising a question, are the judgments binding on Delhi? That's a question, the tribunal say they are binding, I'm with you.
GST, you may say that it is a...
Now there are n number of High Court judgments in GST regime.
Yeah.
Bombay High Court judgment in 74 independence not binding on Delhi. We have done right from 17 brand equity case, it was not accepted. No-sale case was not accepted by any High Court.
It is not applicable as per the DGST is concerned.
I'm discussing GST mechanism. The case of, my lord, the case of brand equity where they invoked 3-year limitation, it was rejected by all other High Courts. That was also an interpretation of a federal enactment. There is no ruling which is binding. We are talking about taxability. Now supposing my lord agree that they pass this notice. Tomorrow Supreme doesn't agree?
No, today we question.
So what we are fairly saying is, we will create tax liability, we will keep the recovery in abeyance. That's a fair treatment to a client. They are not paying anything to me.
What we feel is that reading Schedule 3, paragraph 5, it says sale of land and subject to clause B of paragraph 5 of Schedule 2, sale of the building.
One second.
Yes. The Gujarat High Court and followed by Bombay High Court.
And followed by Alpha.
They have only interpreted this part. 1.5 lines they have interpreted that this kind of an assignment right, which was given from Gujarat Industrial Development Corporation.
I fairly concede. They say there's nothing but a sale of land.
And my DC
That's why they say. What I'm saying is, if matter was till Supreme Court gives a final verdict, if matter was not pending in Supreme Court, even then I wouldn't have agreed as a revenue concept.
My issue is,
what we are saying is that let tax liability be raised, we will not recover. That's all.
Okay, then to that understanding that we
yes,
agree with you.
Yes, case can be remanded, we will not recover.
Even for that matter, appellant stands to win.
Yes, let him win. Yes.
Subject to the fact that the recovery will be kept on against.
Yes. That's a fair deal to the appellant. They will not pay anything. But revenue also will not be devoid from the right to tax. If you win, has been. Well done, Himanshu. God bless you. हाँ तो बड़ा साहब लगता है रेवेन्यू को मेहनत नहीं कर गया है कोई बिल डिसमिस ही नहीं हो रही Before we take a tea break,
Good morning everyone. कैसे हैं आप लोग? मेरे हाथ में ये चश्मा है, पेन है, ये चश्मा है, ये चश्मा होता अगर चश्मे जैसा दिखता, तो आप भी अच्छे हैं तो अच्छे जैसे दिखने चाहिए। कैसे हैं आप लोग? I would like to express my heartfelt thanks for this program to all the organizers, especially सुशील वर्मा जी। इस तरह के जो सेशन हैं बहुत ही मीनिंगफुल, सीखने लायक, काफ़ी अच्छा एक्सपीरियंस मेरा रहा। लाइव ट्रिब्यूनल जैसे काम करता है, बिल्कुल उस तरह की फीलिंग्स, और जो नए लॉयर्स हैं उनके लिए तो बहुत ही अच्छा है। और आफ्टर 2-3 years I also feel a coming future I would be part of your your fraternity. I'm also graduated in law from Delhi University, and I also earned post-graduation degree also from the U. This is very wonderful experience. और स्पेशल थैंक्स मैं दोबारा कहना चाहूँगा आज के लिए, और मैं चाहूँगा कि इस तरह की जो लर्निंग है, इस तरह के सेशन है वो कंटिन्यू रहें, और मुझे आप बुलाएंगे तो मैं डेफिनेटली आऊँगा। इट्स वेरी सीखने के लिए बहुत ही अच्छी चीज़ें थी, अच्छे टॉपिक आप लोगों ने चुने, जो भी डिस्कशन हुआ, जिस तरह के आर्गूमेंट हुए, बहुत ही बेहतरीन। थैंक यू वेरी मच।
Residential property versus Commissioner DGST. The case will be argued by CA Mayank Ahuja, and the case is about pure agency.
Good afternoon, respected member and respected Dinesh Government Counsel. May I proceed? So I am representing.
आपको सैटरडे को भी बताया था कि जो आपने अपील फ्रेम करी हुई है ना, अभी मैंने सबको बता दिया कमिश्नर। अब ऊपर आपने यहाँ पर भी, अब यहाँ जॉइंट कमिश्नर लिख रहे हैं ऊपर असिस्टेंट कमिश्नर इंडेक्स में लिख रहे
I mentioned passed by joint commissioner, not against. In
हैं।
first
पास
place,
पे जो है तो वही है ना, वो इसको करेक्ट कर दीजिएगा ना।
Mr. Counsel, those procedural defects हैं वो हम आपको बता देंगे ताकि से देखें, it's not a big issue, सिर्फ APL
इसका ध्यान रखने का।
आपने नहीं लगाया है ना?
APL 05 आया तो टाइम है।
नहीं, APL 2 acknowledgement आपने नहीं लगाया, ठीक है? और चालान फॉर डिपॉजिट ऑफ फॉर फाइलिंग द फीस अपील की जो
मैम है DRC 03 का अटैच।
आज लगाया है आपने,
हाँ जी।
हाँ तो वो पहले नहीं था, ठीक है, ओके।
Sir, I am representing my client AK Residential Society, which is an unregistered residential welfare association. Basically, this society is formed on 1st April 2024 on no profit basis. Basically, society is working on a mutual basis. They are just collecting, they are only providing maintenance services, but collecting utility payment and some tax payment like property taxes, and just submitting to the respective authority. So this case is basically involved around four ground of law. There are four issues of ground of law, question of law. Whether mutuality survive under GST regime, this question. Number two, there are four questions of law. First is whether transaction between an association and member constitutes supply or not. Number two, whether retrospective insertion of section 7 subsection 1 clause AA is constitutionally valid. Number third, whether reimbursement and statutory dues levies form a part of taxable value or not. And last question is whether section 74 invocation is legally sustainable or not. I am coming one by one. Ground number one is transaction between association and its member. Basically, here we apply a doctrine of mutuality. There is a recently case law by Indian Medical Association in Kerala High Court, though it is not fall in my jurisdiction, but I am taking some facts from the case. It is saying that there is a concept of mutuality because one cannot supply to itself. Okay, so we cannot consider it as a supply. So this is the ground number one. Ground number two is invalid retrospective amendment. There was a case law, State of Bengal versus Calcutta Club, where it was held if in case of a mutuality there will be no supply. But Constitution has made an amendment retrospectively. Please note the word retrospectively. From since the beginning of the GST, it is saying that this is a artificially created creation of 2%, and they are taxing on the supply between residential RWA and the members. So we rely on the Kerala High Court judgment that this is the ultra virus. Okay, and the same issue is pending before Supreme Court of India, and we require protective interpretation and benefit of doubt must go to the taxpayer till the matter is settled. Okay, number 30, incorrect valuation under section 15. As per section 15, we are not taking care of pure agent services. In my lecture, I have attached member-wise collection sheet. You can refer my paper book page number 49. I have mentioned member-wise collection sheet and make a reconciliation where I try to establish there is no profit motive has been involved in this transaction. What is society is doing? Suppose there is a bill coming from BSBS, okay, on the basis of different flat members, someone having an area of 1500 square feet, someone having a 2000 square feet. So we are not charging consolidated amount, we are charging on the basis of different flat amount. If area is 1000 square feet, then electricity consumption will be different. In case of bigger flat, consumption will be different. So we are basically charging whatever actual demanding by BSCS now or Delhi Jal Board. We are depositing exact same amount. So for this we have made a reconciliation also. There is no opening balance. Whatever amount is collected from the members, we are depositing to the vendors or different authorities. So for the trail, you can check bank statement. Whatever amount is collecting now, we are exactly deposited to the same authority. So there is no markup involved. So we pray you kindly delete this reimbursement part and pure agent part and make a recomputation of valuation. Last, ma'am, very important issue, wrong invocation of section 74. There is a jurisdictional defect because as per recently amendment, whatever my case is belong to tax period 2024 to 2025. In this case, so-called notice should be issued under section 74A. But in this case, so-called notice has been issued under 74. So this is a jurisdictional defect. So we pray to please completely quash this demand. And if you want to give the direction, please give the direction to our lower authority for re-educate and please listen to our fact carefully and we will submit all the submission again.
Well, friend, this is a case, before you come to his argument, where there is a club or a kind of a society which has members governed by RWA or by the executive committee of a club. They say if the club gives service to its members, can this be a supply for a consideration to invoke section 9 to tax it? In sales tax regime, there was a judgment by Supreme Court that came from West Bengal, Calcutta Club, where they said the doctrine of mutuality shall govern the rule of law. You cannot make a sale to yourself. Let's welcome our other chairman, judicial member, Dr. Rakesh Agarwal. हमने अग्रवाल बना के छोड़ना डॉक्टर राकेश कुमार यार है ना हैंडसम मुंडा लग रहा है तू पूछ रहे हैं हाल What do you have to ask him है why make him conscious कि मैं बीमार था हाँ belated happy केक भी आया यार मैं बोला था केक लेके आना आया देखा Okay, so they said that you will invoke doctrine of mutuality. That is, a sale cannot happen to oneself. That is, there was no differentiation made between members and the club. They said they are one. When this case was put up to GST Council, and when they read the definition of goods and service, they put up a big legal note that we should amend the law. So they amended the law by way of 7.1 AA, that this will be taken as supply and taxed. So the legal note did say specifically they are overruling Calcutta Club case, but they gave a reasoning that this is deemed to be a supply and therefore taxed. Now my friend says that there is a Kerala High Court judgment. The judgment came in 25. Did you know in 24? So when you read judgment, be careful about dates. That's a lesson.
This case, right?
No. Your society was formed on 24.
24, yeah.
The judgment came in Kerala High Court 25. Why did you not take the number at that time? There was no judgment.
For similar facts,
No fact. Judgment came in 25. So 1 year you took it for granted कि Kerala High Court हमने manage कर लिया पर हमारे बात में दे देंगे. So when you read High Court judgments, be careful about dates. That's a lesson you have to learn. Right? Now the case came to Kerala High Court, Indian Medical Association, and the revenue applied the same parity. The association club are same. So if they are rendering any services to their medical associations, they should pay tax. Kerala High Court examined Calcutta High Court judgment, Calcutta Club judgment. They say, okay, no, this retrospective amendment is invalid. Now, they gave certain reasons which are still before Supreme Court. Supreme Court has stayed the recovery against Indian Medical Association members till we decide. Now once the issue here is, in the quest of Kerala High Court judgment, now this is not of this case, should the club not take the number? So you are moving in a very risky territory, very risky. There can be prosecutions, there can be arrests. So if in the quest of a judgment which is not binding in Delhi or in any other state for the time being, should you not take number? And in his case, the society came into being 1 for 24, they are collecting money and putting in bank. Right? So when you take these kind of arguments, based on a judgment you did not take the number or is favorable, you have to know when did your liability start. Your liability start on 1st for 24. This judgment came in June 25. So this becomes a very risky proposition for an appellant and his client. Okay, what do we do now? Now their case for the lower authorities was they were collecting a lump sum amount, 27,000 or 42,000 for penthouse or a 3-bedroom house. There was no bifurcation given below. And then they also took a ground, they have Honorable Prime Minister for seeking assumption, these being RB retired people. So you did not take number on this ground also, that's no ground at all, that's a policy issue. We are not concerned with any policy issue in the GST regime.
It's applicable to the policy.
Yes, yes. Now the question is, you have to read section 15, 2A, B, C, D. These talks of what are the inclusions. And inclusions are all that what has been mentioned in Shoka's notice and the adjudication order. So unless you read section 15 first, then you go to chapter 6 of valuation rule 28, what could be excluded. So all that a society charges the member other than GST taxes is included. Unless there is an exclusion. Right? So society ने कोई भी पैसा लिया, किसी भी तरह का member ने पैसा लिया, this is an assumption, this is towards services. There can be nothing else. Including donations, whatever you charge. Now my friend says that these are 4 or 5 things where there was a pure agency. You should have annexed the society agreement. No, that's not a society agreement, that's an agreement. When you gave him an allotment, the pure agency has to come from that, not subsequently. The property tax is leviable from where? When you were given allotment or even prior to allotment. लिखा होता है ना, up to date of allotment we will pay taxes, after that you will pay. Right? For pure agency you have to read rule 33. And even in your paper book there is no such evidence brought on record that this was a case of pure agency.
I am supporting member agreement.
How does it matter? It says what payment you made on behalf of the member, right? That exact payment that should have come to you, that is pure agency. Not 1 rupee less, 1 rupee more. That is, if you paid towards property tax out of 23,000, 2,000 rupees, you recovered from member 2,000 rupees only, not 23 in bulk. So if you have 5 transactions of pure agency, you have to prove that these 5 transactions are exactly reimbursed by the member as per the bill. When does it happen? When does it happen? After you have paid. Other pure agency has no meaning. So nothing has been brought on record that you satisfy rule 33. एजेंसी कब आएगी? जब आपने पेमेंट की, बाद में पेमेंट ली. दोनों डॉक्यूमेंट चाहिए आपको दिखाने के लिए. If you are seeking exemption worth crores, who will give you? Revenue officer will not give you exemption on this.
You are supporting member wise allocation sheet and reconciliation.
There is no question of allocation. This is your private allocation. Taxes are paid to the government. Any NDMC, MCD, whatever authority. Water charges to Jal board, electricity so and so. So their bills have to come. Now the question is, can a society bifurcate the overall bill between self-consumption, private consumption, amenity? Answer is no. So pure agency is very difficult to invoke under these circumstances. Since you don't have documents here, we are not going through it.
I have something very interesting. Department has written SCN also an adjudication order which states a payment of 27,000 for the 3-bedroom house and 45,000 for the
penthouse.
Is it monthly? Is it annual?
It's monthly.
कहाँ लिखा?
हाँ नहीं लिखा, but if you read tax calculation, they have no dispute.
No. But SCN should say
I appreciate you.
monthly or annual.
No, but the tax calculation, they have no disputed.
That's why I am telling
Yes,
the appellant.
we should have disputed. Yes.
Appellant should have said that this 27,000 is monthly or annual, and 45,000 is it monthly or is it
monthly.
annual? Let him say whether you read it in the SCN, whether you read it in the order, whether you read it in the appeal.
I was about to tell you that these technicalities when you read an order should also be cleared. Not that really makes a difference. This can be rectified.
अभी तक हम समझते थे ये ऑडिटर की नजर ही होती है जो इन चीजों को पकड़ती है, लेकिन वकील को तो और भी ज्यादा आगे होना चाहिए. ये कहीं भी नहीं लिखा हुआ.
Right to say, Kerala High Court judgment which came in 25, this is only one judgment in India that has gone to Supreme Court. No other High Court has followed Kerala High Court. There are a lot of writs pending, but they have taxed. Right? This judgment is pending in Supreme Court, though there is a stay on recovery amount. But your case is totally different than Kerala High Court. Your liability came from 1/4/24.
बाकी चीजें हैं जो 1/4/2024 से सोसाइटी बनी है और इन्वोकेशन ऑफ 74 इज ऑफ कोर्स नॉट गुड.
Both the technical point, we had told him take it later so that we discuss marriage.
दोनों की परमिशन से हम खुद ही लिख लेते हैं इसमें. चलो as if SCN has come with section.
Rightly so, yes.
That is second thing. Valuation में you don't stand क्योंकि उसमें कोई भी एजेंसी वाला जो प्रिंसिपल है ना, सिर्फ इलेक्ट्रिसिटी के बिल में हो सकता था यदि आपने बिल सेपरेटली पे किए होते तो. ना तो आपकी रिप्लाई में कहीं मेंशन है एजेंसी वाला जो एजेंसी के लिए जो क्राइटेरिया चाहिए होते हैं ना, collected the amount from the members directly for payment to the authority on their behalf. So that should have come out clearly. वो नहीं आया है. और फिर the way it has been collected lump sum, अच्छा you have not collected any separate amount for deposit of electricity.
No, in my lecture I have shared the invoice format also.
चलो दूसरा किसी ने भी there is an exemption notification of 7,500, उसमें आप आते नहीं हैं क्योंकि 7,550 रुपीस भी अगर हो जाता है तो entire amount becomes tax.
Now there is a little confusion on this issue. Okay, whether the liability of society starts if charges are 7,500 per year. Madras High Court issued 2 rulings. If you have 8,000, you pay tax on 500, not on 8,000. There are 2 High Court rulings. Like I said, revenue will follow this only. But we should know there are 2 contrary judgments. Okay, whether you pay on 8,000 or 500. High Court है सर, हम तो वकील लोग, हम तो फायदे वाली पहले बात करेंगे, हमें रेवेन्यू से क्या लेने देना है, यहाँ मुझे रेवेन्यू से लेने देना है, प्राइवेट प्रैक्टिस में कुछ लेने देना है भाई. My lord, I don't mind if the case is remanded with directions to produce all these reports before the law authority so that due tax is collected.
There is a property tax component. There are 2 components. There are 2 components property taxes. This can be fall into pure again, no? Because property tax is not any markup involved. Whatever amount is levied by the authorities. As per valuation.
Again, what the revenue is pointing out, that you can't have the definite amount. You are collecting something else. You are depositing something else. A direct bill for a particular flat owner, if it comes, suppose 1,000 rupees. You are not depositing.
You go to Bombay, all members have their individual meters.
We don't have.
You have 4 kind of taxes in society which can be of under Rule 33. Property tax, water tax, electricity bills, non-agricultural land tax rates. जो हमारे दिल्ली में नहीं, पहले तीनों हैं, और कुछ नहीं, आपके पूरी एजेंसी में कुछ नहीं आता. नहीं, गैस नहीं आती, गैस नहीं आती. No. कल को तो आप बोलोगे नहीं हमने ये सफाई करने वालों को प्योर एजेंसी दे दी, फिर तो you will defeat the whole purpose of law.
But if you check the bank statement, there is a totality concept. Whatever we are collecting, we are depositing exact same amount. We are not holding and we are not.
No, it's not your deposit. What they have charged the individual members. The pure agency is not what you are paying. What they have been charged on this member, you have collected the same thing. पहले चार्ज हुआ फिर आपने कलेक्ट किया. If you are charging in advance by way of bulk, pure agency goes.
So it is a non-profiting organization. तो हम एक ये प्रिजम्पशन लेके चल सकते हैं, इट विल नॉट हैव अ कॉर्पस. कॉर्पस जो जनरेट होगा वो थ्रू प्रॉफिट होगा.
कॉर्पस आपके थिंकिंग पर कितना बड़ा करोड़ों रुपए का कॉर्पस है भाई.
सर लेट मी. या दूसरा तरीका ये होगा कि वो मेंबर्स से कुछ कंट्रीब्यूशन लें और एक कॉर्पस को क्रिएट करें. दो तरीके हो सकते हैं. इट इज ईदर द प्रॉफिट earned by the RWA or the amount which has been received as contribution and if permitted by the norms of RWA. अब सर आपने और जैसे members ने कहा कि the amount has first to be paid by RWA and subsequently recovered. तो जो payment है it may run in crores.
इनके केस में
सर किसी भी केस में कोई भी RWA it has first to be paid. तो उसका source क्या होगा?
Let us say not paid, you get the bill first. Then take money and pay them. That's okay.
Sir, हर society
you don't pay. I'm saying don't pay, but first get the bill.
Sir, basically problem क्या है
कि हर your answer question is answered. कि you don't pay.
Right.
बिल तो आएगा ना आपके पास पहले. इस पर reimbursement कहाँ से लेंगे? बिना बिल के reimbursement ले लेंगे? Is it possible? Possible नहीं है.
Sir, हर सोसाइटी में एक हर फ्लैट का एक इंडिविजुअल मीटर होता है.
नहीं होता सर, नहीं होता.
हर केस.
अरे अच्छा ट्रिब्यूनल ये क्वेश्चन आएगा ही नहीं ना, फिर तो खुद पे करेगा. फिर तो वो खुद पे करेगा. प्योर एजेंसी का मतलब ही नहीं.
देयर इज अ क्वेश्चन. सपोज लाइट चली जाती है, दे ऑपरेट डीजी सेट, उसका एक अलग मीटर आता है, तो वो डीजी सेट की जो आपकी मीटर जो रीडिंग आती है वो पैसे कौन लेता है?
अगर मीटर आपका फिर तो प्योर एजेंसी की कंसेप्ट ही खत्म होगी ना. वो तो आपका बिल है, आपने दे दी, मैं सोसाइटी को क्या लेने देना उससे.
सब वैसे हर सोसाइटी में हो गया है कि वो इंडिविजुअल मीटर्स
पटपट में जाओ ना.
सब मीटर हो गया ना. तो सब मीटर इज व्हाट इट इज द बेसिस ऑफ कैलकुलेशन कि आपका जो कंट्रीब्यूशन टोटल जो बिजली का बिल है कितना होगा. दैट इज राइट ऑन द बेसिस ऑफ
अगेन दिस विल नॉट सैटिस्फाई योर रूल 33.
Sir, if it's an individual bill, then the slab rates apply. In this case, you will be paying on the maximum, which is 8 rupees and 40 paisa. And not, in societies, but that 200 free will not be given to me.
In any case, जो भी करना है अपने को करना है कि मेरी प्योर एजेंसी है या नहीं, हमें उससे क्या लेना देना है.
It was just an academics.
No. You have to come in rule 33 explanation. और रूल 33 में उन्होंने एग्जांपल दिया है कैसे प्योर एजेंसी वर्क करती है. लॉ मेकर ने एग्जांपल दे रखा है आपको. मेरी स्टेटमेंट उस एग्जांपल के बेस पर ही है.
सर मेरा सिर्फ सबमिशन इसमें ये था कि जो पहला पेमेंट वाला जो
आप पेमेंट ना करो, मैंने कहा ना करो. बिल तो आपके पास हो तभी. आपके पास मयंक अहूजा के नाम 4,332 रुपए का बिल है. वो पेमेंट 4,332 आपको करनी है, 5,000 नहीं कर सकता. बट दैट्स इट.
बैक टू बैक जितना आया उतना गया.
You are chartered accountant. What's the meaning of reimbursement? Reimbursement cannot include your commission and profits and rishwat. Reimbursement is very clear कि कितने दिए कितने लिए. For example, as you form companies, I have given an opinion to one of the big fours. All this is taxable. You have to take receipt in the name of client, and he should be separately reimbursing that amount to you. ये अभी नोटिस आने वाले हैं बड़े बड़े लोगों को कि भाई ये जो तुमने सारा कर रखा आपने, ये इसका हिसाब किताब क्या है.
सर एक क्वेश्चन और एक ये कि जैसे हम लोग वो है कि टैक्स ले लेते हैं अपने एसएससी से. टैक्स हमने डिपॉजिट करा दिया गवर्नमेंट को, राइट. फिर हमने उनको बिल दे दिया.
ये भी आपका आपके एक अलग अकाउंट बनाते हो, कस्टमर टैक्स कलेक्शन अकाउंट.
पार्टी अकाउंट.
ठीक है, उसका आपका क्लाइंट के साथ एग्रीमेंट होना चाहिए.
अगर नहीं है तो
नहीं है तो come to lawyers. When you are taxed, come to lawyers who will defend you. पैसे लेके. आपने कभी रूल 33 पढ़ा है आज तक? पहले पढ़ो फिर बात करना. हमने पढ़ के बात कर रहे हैं. नहीं, not paper. Simply exchange an email कि whatever tax you give, it will come to this account, not in our regular account, and we will tell you what is the exact tax amount. अब आपने टैक्स उसे 10,000 रुपए भेज दिया आपको लमसम, उसका बना 3,000 रुपए. कैन यू से दिस इज रियम्बर्समेंट? आंसर इज नो. 7,000 किस बात के लिए थे आपने उस अकाउंट में? तो अगर मैं आपको अकाउंट रिकॉन्सिलिएशन करने बैठ के और आपका सर्टिफिकेट मांग ले कि कितना पैसा है, कितना हमने जमा कराया, You will be cornered, boss. Why should you invite a liability for which you don't make money? It's as simple as this. एक तो साले क्लाइंट की फ्री की सर्विस कर रहे हो, खामा को उसका टैक्स इकट्ठा करके जमा करा रहे हो, वी आर डूइंग ए क्लरिकल जॉब, उसके बाद ये इतनी बड़ी प्रॉब्लम आपके अकाउंट में 50 करोड़ रुपए इकट्ठा हो गया, मैंने आपके रेड मारी DGST में, बोले क्या है, बताओ 50 करोड़ रुपए, एग्जम्पशन किसको लेनी है? आपको लेनी है सर, उनको नहीं देनी. It will be very difficult to prove what is this 50 crore. अब बोलेंगे ये टैक्स रिएम्बर्समेंट होगी, साहब दे दो, ये सीधे होगी आपके पास. नहीं सर वो उसका टैक्स बन रहा था, हमने देना था, ये करना था, वो हम वकील झूठ बोलेंगे. They are all be taxed as your income. हाँ तो ठीक है, if there is an agreement, you prove it, chapter close, they will not tax you. So rule 33 require a contractual agreement. हम तो रूल 33 पढ़ क्या बोल रहे हैं आपको? नहीं, फालतू ईयर नहीं लिखा, उसको कंटिन्यू कर लो. पर एक करने में नुकसान क्या है मुझे बताओ? व्हाट इज द बिग लॉस? व्हाई शुड वी इवन डिबेट दिस इशू? एक लॉ कहता है जो फॉर्मेलिटी आपको करनी कर लो भाई, ईमेल तो लिखनी है, लिखना क्या है?
One for the 3 bedroom flat, another for the penthouse. And now that it is verified, this amount charged is a monthly one. So in any case, GST leviable slab में 7,500 per month से ज़्यादा आता है, is taxable. Now the question arises, which my learned friend says that some of the amount they have collected as a pure agent. But prima facie, it's a question of valuation, where section 15 clearly says that value of supply of goods or services or both shall include a transaction value, and it shall include any taxes, any duty, cesses, fees, charges,
all the 4 clauses,
सब कुछ मिला के except for CGST और SGST. That means यदि आपने कोई टैक्स भी कलेक्ट किया है, और म्युनिसिपल टैक्स भी कलेक्ट किया है, और वो 27,000 में और 45,000 में included है, that is also a value of supply. Now your question comes a little bit on a fact. You say, oh sir, some of the amount is as a per taxes, some of the amount is for some certain levy which you have collected on behalf of the some other agency as a pure agent. But pure agent की जो criteria है, that you have to fulfill. To that extent, that learned DR is also kind that he is willing to take your case in remand, to the extent that you can prove that, okay, out of the 27,000, 3,000, 5,000, 7,000 is for pure agency, and for that you have to meet all the requirement of Rule 33, which says that the supplier acts as a pure agent of the recipient of the supply when he makes a supply. Payment is made as a pure agent on behalf of the recipient. That means when as a society you collect the money from those people, whether before or after, those receipts by the department should be in the name of the individual people. You deposit some electricity bill on behalf of the occupant, so bill should be in the name of those people. You only collected money and deposited. These kind of things are there. To that extent, you may be able to reduce a bit of your liability, but on a substantial part, we don't see any escape. You still have to pay the tax.
And get registered.
And get yourself.
See, if you don't get registration, what happens? Let us say the Kerala High Court judgment is ruled against by Supreme Court. Then 122 say 10,000 or 10% tax, whichever is higher. So you expose your client to this kind of a liability by a stupid interpretation based on a one High Court judgment. As a lawyer, I never trust any High Court judgment till we have a Supreme Court or Delhi High Court. So therefore, whenever you take a call like this, you don't go for registration with such heavy amounts, which you have collected and put in your bank. So it has huge liabilities coming up. See, arrest wala case कब से चला था? 2018 से राजकीय अग्रवाल came in 25. 7 साल तक लोग गिरफ्तार होते रहे, अरेस्ट होते रहे, असेसमेंट कितना वकीलों करोड़ों रुपए वकील खा गए हम लोगों के. हम रिट करेंगे, ये करेंगे, वो करेंगे. They were Supreme Court against you. But now they say you can be arrested without assessment. वो तो पहले बोला पीवी केस में ये बोला था आंध्र प्रदेश हाई कोर्ट ने. Therefore, whenever you take an opinion or give an opinion, put yourself in the shoes of client. अपना पैसा नहीं देखना. Because you can't expose your client. केरला हाई कोर्ट है सब देख लेंगे. तुमने कुछ नहीं देखना भैया, क्लाइंट ने देखना है. सुसाइड उसकी है, आपने तो ना मरना. आप वो मर के देखेगा, सब कुछ खत्म हो गया मैं. Therefore, this is a case. I think the honorable chairman raised a very important question. Can rule override section 15? Section 50 does not give you deduction of pure agency. But if you see rule 28 to rule 34, there are three kind of agents. You are talking of one. There is also a relationship principle and agent. I mean deduction milti. But you have to reconcile with section 15. Now this cook and bull story which you can create here in a Moot Tribunal, if it's a real tribunal, they throw it out. Because nothing has been pleaded below.
On registration itself,
right? And you have not taken registration.
That's most crucial.
If you take 74A, it basically now applies to registered person, except to the extent you have not paid tax. Short pay कौन करेगा? जो registered है. Input कौन claim करेगा? Registered है. Refund कौन लेगा? Registered है. So you fall in the first limb of 74A. That is why they are not using the word registered person. They are using person charged to tax. बस उसमें 4-5 में 3 तो registered के applicable है. Have you understood my point? Short pay कौन करेगा? जब मैंने टैक्स किया कभी शॉर्ट पेमेंट होगा? इनपुट टैक्स तो अनरजिस्टर्ड क्लेम नहीं कर सकता, रिफंड भी उसको नहीं मिलता. तो सिर्फ एक पॉइंट पे आपका पॉइंट है. But you are exposing your client. Now supposing in your video examination, call your members. They say they have collected GST from us. You come to 131D, you will be arrested. Within 3 months, you must deposit tax which you collected from behalf of the government. So this was a case where some more work should have been done. You have done a wonderful job. But legally, it's a long way to go. I think Honorable Chairman raised a good question. Can section 15, the rules are applicable for this chapter of rules. लिखा है. Falafel rule under this chapter. That is the valuation chapter. They do not refer to section 15. So this is a debatable question. Will those rules help you to exclude? My opinion is yes. It's a debatable question. Can a rule override section 15? Section 15 में 4 exclusion है. For example, debit or credit notes. You can do on your own. जैसे law. क्या लोग बोलते हैं? बाद में रिवर्स कर दिया तो हमें बेनिफिट मिलना चाहिए. No, I will not give you benefit. His reversal has no dependence on your output tax reduction. You have to prove did you issue a proper credit note. अगर आपने 34 को वायोलेट किया या आपके पास एग्रीमेंट नहीं था, जो भी नहीं था, you cannot get output tax reduction. Only on the premise के बाहर ने रिवर्स कर दिया. Buyer obligation is towards receipt of input tax credit. Your obligation is to pay correct output tax liability. दोनों अलग-अलग चीजें. So when we read law, we have to be very careful. Well done. All 5 appeals are allowed today. फिर कहते हैं गवर्नमेंट को बेकार है. हाँ जी.
जैसे लर्नड चेयरमैन ने कहा कि जो रिसीट्स हैं दे बिकम टैक्सेबल. हम सिर्फ इतना पोर्शन को देखते हैं. बट एट द सेम टाइम वी हैव टू मेक अ डिस्टिंक्शन बिटवीन अ रिसीट एंड द कॉरस्पॉन्डिंग सर्विसेज जिसके लिए वो रिसीट आई है. जैसे हम एक रिसीट को आइडेंटिफाई कर रहे हैं तो वो टैक्सेबल है सर ने कहा. बट दैट रिसीट इज अगेंस्ट व्हाट? इट इज अगेंस्ट द पेमेंट ऑफ हाउस टैक्स.
ये उन्होंने ये नहीं बोला आपको कि एग्जम्पशन क्लेम करनी है. यू शो अंडर व्हिच क्लॉज यू आर एग्जाम्प्ट, यू विल गेट एग्जम्पशन.
नहीं सर, मेरा कहने का जो सर्विस है,
आपके कहने का मतलब ही कोई नहीं ना सर. एग्जम्पशन आपको क्लेम करनी है. आप कहते हैं रसीद हमारा लोन था, हमने लोन के पैसे दिए थे.
सर टू बी टैक्सेबल
ये कहीं नहीं लिखा था.
सप्लाई हैज टू बी गुड्स और सर्विस.
ये कहीं नहीं लिखा था
सर.
सेक्शन 9 में कहीं नहीं लिखा है
सर. गुड्स से सर्विस किसी तो कैटेगरी में आएगी ना.
हां, तो
अगर हम यहाँ पे गुड्स है
इंटेंजिबल हो गया, consideration you receive, this is presumed to be for rendering services. You want exemptions, exclusions, there are rules. Get it?
हाँ सर, मैं बिल्कुल वही कह रहा हूँ कि जो हमारी रिसीट है उस सिचुएशन में वी हैव टू आइडेंटिफाई दिस इज द रिसीट.
करना आपको रेवेन्यू में नहीं. आप करो एग्जम्पशन लो, क्यों नहीं?
इट इज अगेंस्ट पेमेंट ऑफ हाउस टैक्स. मैं मतलब
वो एग्जम्पशन आपको लेनी है सर.
यदि अगेंस्ट पेमेंट ऑफ हाउस टैक्स भी है ना, एंड यू आर चार्जिंग ए लम सम अमाउंट इंक्लूसिव ऑफ हाउस टैक्स, इस डिपार्टमेंट आपको हाउस टैक्स कम करके बाकी कोई जीएसटी नहीं लगाएगा. सारे को सारे को
नहीं सर, मेरा कहना ये है कि अगर हमारा 3 रिसीट्स हैं, जैसे A B C D, जैसे हाउस टैक्स है, इलेक्ट्रिसिटी, वाटर बिल एक्सेट्रा, उसका मैंने कंपोजिट अमाउंट ले लिया 10,430 रुपये, एंड दैट अमाउंट इज स्पेंड बाय द RWA फॉर ABCD, जो भी उनकी वो जो एक्टिविटीज़ हैं उसके लिए उसने एग्जैक्ट अमाउंट इकट्ठा कलेक्ट किया और उसके बाद उसने उसको स्पेंड कर दिया एग्जैक्टली सेम अमाउंट। तो मेरा ये मानना है, हाँ, इन दैट सिचुएशन ही हैज अ केस कि उसको वो आइडेंटिफाई करना पड़ेगा। हाँ बिल्कुल बिल्कुल सर, ये
प्योर एजेंसी जनरली फॉर गवर्नमेंट टैक्सेस ओनली, अदरवाइज ये इज नॉट टॉकिंग गवर्नमेंट टैक्स।
आप रश्मि जी के पास गए कि मेरे लिए कंपनी फॉर्म कर दो,
बिल्कुल नहीं करेगी।
एक मिनट, विदाउट पेमेंट जब 10,000 दोगे कंपनी फॉर्म कर ऑल इंक्लूसिव, नाउ दिस फॉर्मेशन ऑफ कंपनी फॉर 10,000 इंक्लूड this formation of company for 10,000 include 3,500 rupees as a ROC fee. Now she will charge GST on the entire 10,000. In case you want to take an redemption of the amount paid on your behalf to the ROC, then you have to say separately ROC की फीस आपकी इसी के अंदर included है. Then she has to take a receipt from the ROC separately and give it to separately. And then for the rest of the amount she will charge GST. अगर हमने ये अगर ये इन्होंने कह दिया कि 10,000 में कंपनी फार्म कर दी इंक्लूसिव ऑफ टैक्स, इंक्लूसिव ऑफ ROC फी, तो 10,000 के ऊपर GST लगेगी।
अगर उसने 7,500 का बिल अलग से किया है,
हाँ
3,500 इसका दिया, तो
हाँ that kind of a paperwork
नहीं, वो 3,500 रुपये एग्जैक्ट अमाउंट है जो आपने दिया है। हाँ उसमें तो भैया सही है सर,
रसीद भी आपके नाम से बनेगी।
इसका सपोजिंग इज वर्किंग फॉर ए जैन सोसाइटी, वो कहते हैं जी हमने महात्मा बुद्ध का बर्थडे मनाना है, उसमें 10 करोड़ रुपए लगेंगे, आपके 10 मेंबर है, सब 1-1 करोड़ रुपए दे दो, इज दिस रियम्बर्समेंट? सर नो।
तो यही
चलो आगे चलें। शांति करें।
10,000 अगर आप देंगे तो 10,000 के ऊपर नहीं, ये कहेंगे 3,500 रिइंबर्समेंट और 6,500 फीस, तो 3,500
यार तो फीस दियो ना, मैं बता दूंगा क्या करना है यार, तो मेरे को पैसे देने सीखो ना यार, ज्ञानी पैसे देने सीखो। वो एग्जांपल में लिखा है, बस वही इंट्रोडक्शन है। चलो,
the bench is over for the day and I thank all the 3 judges.
Let them keep sitting here, I don't mind speaking in front of them. नहीं, let the tribunal remain there.
Okay?
Extension of tribunal activity. नहीं सर, आप बैठे ना ऊपर यार, अच्छा लग रहा है। चलो
स्टार्ट करें। तो next in the pipeline is a very interesting lecture on matter on Shanti Kiran Industries. So let's hear our mentor SV sir on this issue, ITC. Sir,
if you want to understand, I need to endure half an hour, 45 minutes exact. No questions at all. If you want to understand what is the mechanism of input tax credit.
Sir, if you don't mind, हम bench over कर देते हैं, हम आराम से बैठ के यहाँ पे।
नहीं, मैं ठीक हूँ यार। The biggest dispute of GST mechanism in this country is only one. That is claim or no claim, legitimate or illegitimate, ethical and unethical claim of input tax credit. Whenever you claim an exemption or a concession or a deduction, all three are totally different. Exemption is which is given by schedules. Deduction is what is given by law. Concession is like inverted duty structure, 5%. That's a concession. So nature of all these three kind of deductions is in law totally different. You cannot claim exemption unless there is a notification. Like at rolling regime, आपको एग्जाम्पशन लेनी है, एंट्री ले आओ, हम दे देंगे आपको। अब डिडक्शन आप प्योर एजेंसी का लाते हो तो हमें डिडक्शन देनी है, इट डजंट नीड अ नोटिफिकेशन फॉर दिस। So input tax credit has been held to be by Supreme Court a concession given to you. It is not your fundamental right. It's only a right given by a statute under certain circumstances, and those circumstances can be changed by legislature whenever they want. Like we did Safari and Bharti Airtel, कि भी इसमें हम ITC आपको नहीं देंगे. So that is other than section 17 ITC if you are blocked. For other you have a concession, आप बाकी claim कर लो. So whenever you are dealing with a case of input tax credit, as professional always keep in mind you are dealing with a concessional legislation. There is the leading judgment of Supreme Court ALD Automotive versus State of Tamil Nadu, in which they have reviewed many judgments and held that ITC is nothing but a concession. Now, how does this concession work? It works through first section 2. Section 2 defines what is input, that is goods, excluding capital goods. Input service, input tax, input tax credit. All these 4 terms are defined in law. Now supposing a taxable person, a registered person issues you an invoice which is inclusive of tax. Under certain circumstances, law allows it. What input tax credit will you have? How? You can't calculate tax. Tax has to be charged by the buyer, not given by the seller. That is why law says all invoices shall show bifurcation of tax separately in the bill what is charged. For input tax credit, before you come to the judgment, you always have to remember there is a difference between chargeability, charged and paid. When we say chargeability, it means supposing a buyer sends you an invoice कि ये मेरा माइक्रोफोन 28% का टैक्स है, तो इनपुट टैक्स क्रेडिट से what tax is charged to you on the invoice? It's 28%. Now when you are selling the same thing, you also start charging 28%. So it should be 5% or 18%. So you cannot go backward and say that this is buyer's invoice, 28% charge कर दिया. That will be patently illegal. You have to charge the correct tax. What is due? It will not lie in your mouth कि हमने ज़्यादा किया तो ज़्यादा जमा करा दिया. That you are supposed to deposit if you collect tax. But there can be action against you. Why did you charge more? Let us say GST2, जो भी तमाशा हमारी गवर्नमेंट ने किया था, ये हमने कम कर दिया, बड़ी कर दिया. If all of us start charging more, their whole GST revolution will go for a 6. उन्होंने 5 किया, आप 18 चार्ज कर रहे हो. सब 18 हमने दिया आपको. तो जो उनकी वेलफेयर लेजिस्लेशन जो बनाया गया था उसको आज खत्म कर दिया. अब इस पे कुछ कोर्ट अब ये भी कहते हैं, कैन यू क्लेम 28% इनपुट टैक्स क्रेडिट बिकॉज द सप्लायर हैज चार्ज यू मोर? दिस इज बीइंग क्वेश्चनड. आई हैव अ डिफरेंट ओपिनियन, बट few high courts have questioned कि you can get input tax credit what is due in terms of law. But when you see output tax definition, they use the word chargeable. Input use the word charged. Right? So there is an inverse relationship between input tax and output tax. Input has no connection with your output tax. You may be getting 5%, 18%, 28%, 40%, and you may be selling at 5%. That 5% product may have all the components of all the 4 tax rates before you make a final product. So input tax credit mechanism in law, this is the principle of law. It's a concession given to you within strict parameters of law. If you do not satisfy the conditions, you are not entitled to input tax credit. It's as simple as this. ये जो हम कहते रहते हैं हम ये कर देंगे वो कर देंगे, आप कुछ नहीं कर सकते. Supreme Court will give you no relief. unless you invoke doctrine of impossibility. We will discuss this, what is the meaning of this doctrine of impossibility. Section 16 is couched in past perfect tense. So when you read law, English grammar, you must interpret. It helps you. What is your eligibility? When do you become eligible to claim something in law? It uses the word has, and you are eligible. Section 16 does not give you anything. It only makes you entitled to claim input tax credit. That is, it sets out the criteria for eligibility of input tax credit. That is why they are subject to section 49, subject to other sections. 49 tells you how will you take it. So there, all section 16 tells you when are you eligible, when are you not eligible. When you read these kind of substantive provisions, it has three mechanisms. One is a charging provision. That is, when do you get input tax credit? So 16(1), आप registered हो, supplier registered हो, आपने good service, अपने business से खरीदे हो, further no business, or you intend to use. Now the word intention to use is not a illogical phrase. Supposing you buy 10 Rolls Royce and claim input tax credit. It's a genuine case I'm discussing with you. You say we intend to run a travel agency where we will give these cars on hire. You enjoy this input tax credit for 2 years, you don't start this business. Are you entitled to input tax credit? The law says intend to use. वहाँ टाइम तो नहीं लिखा है मैं 10 साल बाद करूँगा, 5 साल बाद करूँगा. I'm on this question. That is, if you are trying to twist the law and claim such credits, this will be a wrongful availment of input tax credit. The wrongful availment of input tax credit is not defined anywhere in the Act. It only defines what is input tax credit. And you should be buying from a registered supplier. That is, the onus is upon you to prove. Forget section 155. It's not required in GST mechanism. When you purchase material, that person was registered. Now supposing he gives you a GST certificate. The law is when you cancel, you have to surrender the certificate. उसने नहीं किया. आपने कहा मैं तो सर्टिफिकेट देखा था, मेरे पास तो काफी है, उसके साइन किया हुआ है. It was your duty to ensure he was registered. There are enough mechanism on portal to know whether his RC has been cancelled or not. And you should be buying goods or services or both for the use or in furtherance of your business. So whatever you buy for which you have a tax invoice, you are buying from a registered supplier, those goods, services or both should be used in the course or furtherance of your business. Intended, forget, let's say used. So the first parameter when this DGI people come out, the question arises, जी आपने कहाँ यूज किया सर? वो आप बिल आता है जी आपने 50 टन स्टील खरीदा. सर आप स्टील का कौन सा काम करते हैं? कोई नहीं करते जी. आप तो खिलौने बनाते हो, खिलौने को ट्रेडिंग करते हो. स्टील का क्या किया? बोले कि वर्मा जी की घर बना सबने वहां लगाया. That is, now onus is shifting upon you. You prove that this steel was used in the course of business or furtherance of business. Business is defined. Business has no connection with profit motive or no profit motive. This is the answer to Rashmi Jain question which I was asking. We work on no profit, no basis. GST law does not require this phrase anymore. इस सेल्स टैक्स में किसी जमाने में होता था. किसी जमाने में फर्स्ट एससीसी एक जजमेंट है इसमें, पहली एससीसी सुप्रीम कोर्ट के, वहां इस फिर को रायपुर ट्रेडिंग कंपनी इसमें डिफाइन किया था इसको. सो यू आर डूइंग बिजनेस फॉर प्रॉफिट और नो प्रॉफिट. दैट्स व्हाई ऑल द ट्रस्ट, religious temples all are under GST mechanism if they are doing activities which are not exempt. Second is, you must have tax invoices. It's like a check. So section 31 requirements must be fulfilled. Normally the invoice format requirements are in rules, but in GST they have written section 31. It's a part of substantive law. Now suppose you write colored cameras for 10 crore. What colored camera? Phone के थे, iPad के थे, film के थे, कौन से कैमरा थे? That is why you have to use the proper HSM code. HSM code will link your product with the tax rates automatically. Description of item. Sony India was hammered in sales tax regime and they closed. They went to Prime Minister के तुम्हारे यहाँ तो stock transfer पे तंग करते हैं. Because they did not give particulars, what did they import and what did they sell. Supreme Court dismissed their appeal. Only on this ground, the description of item was not clear. Canon India, 39,000 crore demand on this companies where they misclassified the mobile phone cameras. This was the only basis. They were not clear what did you do. Had they mentioned everything, this case of misclassification would not come to light. अगर आप इनवाइस लेते हो या देते हो, onus is upon you to prove. When you take, you are claiming. When you are giving, you are authorizing somebody else. That is why in section 132, if you become a anybody else beneficiary of taking or giving input tax credit, it's an offense. That is how you learn interplay of these sections, the provisions for prosecution. 16.2 is a machinery provision. 16.2 says these are the formal conditions you must fulfill. Two are more important. Supplier should have filed returns and supplier should have paid tax. When you say should have paid tax, you refer to 16.5 explanation कि वो टैक्स कैसे पेमेंट करेगा, कैश करेगा या इनपुट टैक्स क्रेडिट से एडजस्ट करेगा. There is a word used, he has paid tax by using eligible input tax credit. The word eligible has a lot of significance. It's not input tax credit alone. Input tax credit phrase is prefixed by eligible. Who's the proof? Department says you prove. Department you prove कि उसने no. 16 is referred to the input tax recipient. Now they are shifting onus upon you, stupidly or whatever you say. Law stands, no court has disturbed it, कि supplier ने आपका tax जमा कराया है. This is on a premise कि GST is always a revenue neutral proposition. जितना उसे टैक्स जमा कराया आपको इनपुट टैक्स क्रेडिट देती है, उसको गवर्नमेंट डजंट लूज एनीथिंग. अब उसे टैक्स जमा कराया ही नहीं, आप झगड़ा कर रहे हो इनपुट टैक्स क्रेडिट दे दो. आपका झगड़ा सही है, हमने पैसे पेमेंट किए. तो 16.2 yes, what they will do supplier is none of your business. सुप्रीम कोर्ट ने बोला है कि सप्लायर के खिलाफ आपने क्या एक्शन लिया, but claim you are taking input tax credit, we are not discussing his liability. उसकी liability अलग है, it goes on a tangent in different consideration. अभी तो हम recipient की बात कर रहे हैं कि आप कैसे प्रूव करेंगे उसने टैक्स दिया.
और जो सप्लायर है उसने अपना 3B भर दिया, हमारा एक क्रेडेंशियल होता है विच इज़ अवेलेबल ऑन दी पोर्टल, तो उससे हमें पता लग जाता है कि उसने 3B फाइल कर दिया. इट मीन्स ही हैज पेड टैक्स. अब एक वर्ड जो है लेजिटिमेट, अब एट द टाइम ऑफ रिसीविंग सप्लाई हमें पता है रजिस्टर्ड है, नंबर 1. नंबर 2 उसने टैक्स इनवॉइस वगैरह वगैरह वो सब पेमेंट वो सब हो गया. अब जो पेमेंट ऑफ टैक्स है दैट गेट्स एस्टेब्लिश्ड एज सून एज ही फाइल्स. So इसमें legitimate जो
word है. Answer this question. Wait, let me reach there. We'll answer this to a 3B returns question. So this 16.2 says formal conditions. Then you have 180 days issue. This issue no court will quash, I guarantee you. Because they do not disallow input tax credit to you. They only restrict Hawala transactions. You suffer 18 or 28% with interest if you don't pay within 180 days. The whole logic of this provision in India was to restrict Hawala circular trading transactions. Right? Then you have 16.4.5 will forget. Now Rajiv question is, you have a 2A, 2B, 3B. These returns are only for the purpose of statistical calculations. They do not lead to any kind of evidence. If that were so, then 74 should not exist. Aapka 3B mein aa gaya, where is the question of doubt? Because the genesis of your transaction you have to prove that you purchase these goods in the course of furtherance of business. And when will you do in business? When you physically receive the goods. Otherwise, how will you do? That is where the Ecom Gill judgment came. We will discuss later. Then you have section 17. And all indirect tax regimes were based on taxable versus non-taxable. So you are entitled to input tax credit if you are making a taxable supply using those goods. You are making a full 100% taxable supply. Or if you are doing exports which are zero rated. They are not zero tax, they are zero rated. And for exports, even if you are making exempt supply, even then the ITC refund is available to you. The ITC losses. Then you have 17.2, business, non-business. So the last time जो स्टील लिया था आपने बिल में, आप कल को बोले जी वर्मा जी घर बना था, हमने तो बनाया था, लेकिन वहां से हमारा ऑफिस भी चलता है. उनका एक 10% ऑफिस भी चलाते हैं आपने. Right? Now the question is, if you prove that this 10% space is used for office and supposing ITC is allowed, then would you be denied 100% or 90%? So that's why 72 says business versus non-businesses. 73.4, then 17.5 were discussed, Safari and Bharti Airtel. Now the question comes, okay, outward supply is made, वो DGST 2.1 बोलते हैं, जो सप्लायर फाइल करता है, जो भी होते हैं, वो आपके रिकॉर्ड में आ गई, आपने डाउनलोड कर लिया. What does law say? You can claim input tax credit to the extent mentioned in DGST 2.1. That's not a law. That is a requirement of procedure. If you can claim more, I don't know. If you can, I'll claim more what I am entitled to. For example, you claim exports. जो आपका डाउनलोड नहीं होता, आप बिल के बेस पे क्लेम करते हो. क्यों करते हो आप? IGST is a part of input tax credit. आप क्लेम क्यों करते हो? Why it is allowed? Because the function of this 2.1 return is only one. There is no other function of this return. It entitles you to adjust that input tax against your output tax liability for that tax period. It has no finality in any sense of the term. Now Rajiv says, उसका 3B आ गया. 3B में सब कुछ है. आउटपुट सप्लाई भी आती है 3B में. सप्लाई भी तो ना आती है. एक मिनट. बाहर का उसमें कुछ आता है? मुझे पता नहीं. Right? Now you say कि 3B में उसने बोला जी मेरा 10 करोड़ का टैक्स था, मैंने पेमेंट कर दी. Right? This has no meaning for revenue. They have to say how did he make this payment of 10 crores. This is where 16.4 explanation comes. If he paid cash, no issues. But he adjusted input tax credit, was his ITC eligible? This is where the bogus billing, non-genuine suppliers come into being. So the function of the returns is only for your benefit कि मैंने जो अभी तक काम किया है वे डॉक्यूमेंट मेरे सपोर्ट करते हैं. But revenue has 6 years to give you, investigate you. 6 साल. 74 में 6 साल से ऊपर है. So now they come कि Mr. Rajiv Jain, to your client ABC Trading Company has purchased from suppliers 10 crore on which 1.8 crore is ineligible input tax credit because the fellow is bogus. And what does he do? 3B. 2.1. Court says, get out. Because unless you prove the genesis of transaction, where is the question of tax? When you read 74A and 122, if you are issuing only bills, not supplying material, you are not being taxed. You are being penalized in 122. It has an interplay. But the person who is receiving material from you, he is being denied input tax credit, also being penalized, also being prosecuted. So these returns have no meaning in terms of legal liabilities. They are a collateral piece of evidence to prove that yes, you have some documents with you. So जितने circular trading के cases हैं, जो bogus cases हैं, वहाँ तो आपको every document you will get in perfect order, receipt भी मिलेगी आपको, but you still have to prove the transaction. अब रीवैम से पूछते हैं सर, ये 10 करोड़ का आपने किससे माल खरीदा था? पता नहीं सर, कोई ब्रोकर आया था, हमने ब्रोकर को थ्रू लिया था. Can this be a business practice? चेक किसने दिया था? सर पता नहीं, एनएफसी से बैंक में पैसे आ गए थे. अच्छा 10 करोड़ को पता ही नहीं किसने दिया था पैसे, आपको you don't know it. That is why these KYC norms are coming into every field of our business. कि आप किससे डील करते हो? There was a case of Delhi High Court where this ST1 form issue was there. I don't remember the case. Some plastic done by Rajesh Mana, our friend, where High Court said if you deal with ban of straw, suffer the consequences. I'm not remembering the case. सेल टैक्स के खत्म होने से 3 साल पहले से केस आया, बैन आने से पहले. क्या आपको पता नहीं आप किससे डील करते हो? Now suppose you get a DGST notice and they call Rajiv Jain's client के tender the statement. Statement किस बात की भाई? 2(1) है, 3(b) है, टैक्स इनवॉइस है, पेमेंट दी है, मैं बिजनेस कर रहा हूं, मेरा धंधा है, आपने इन्वेस्ट कर लिया, अब किस बात की स्टेटमेंट करानी है आपको? Statement is only to winnow the truth from falsehood, कि आपने कितना झूठ बोला आपकी ट्रांजैक्शन. अब वो कहता है कि जो आपने सुशील वर्मा से माल खरीदा, the person doesn't exist, आदमी ही नहीं है वो. जैसे एआई की जजमेंट लगाई, वो कहती है एआई की जजमेंट हुई नहीं आज तक, आपने पिटीशन में लिख दी. वो कहते कैसे नहीं जी, हमने उसको ऑर्डर किया था, हमारे पास ईमेल है, हमने ऑर्डर दिया था, हमारा माल आया था, उसने ऑर्डर एक्सेप्ट किया था, सब कुछ किया था. कहते हैं कौन था बंदा, जानते हैं आप इसको? नहीं सर, वो तो हम तो सील का काम करते हैं, नारायणा मंडी से ब्रोकर के थ्रू काम करते हैं. अच्छा ब्रोकर को लिया सर, वो तो भाग गया. So therefore, whenever you rely on such evidences, this is just 5% of your case. 95% is something else, pure law. In GST regime, we have no Supreme Court judgment. There are 3 key judgments, rather 4 I will say, एक महाराष्ट्र का भी था. First judgment was Arise India. Delhi High Court upheld the contention of the petitioner by interpreting section 9(2)(g) of Delhi VAT Act, which had a almost similar provision like we have 16(4). He must have paid the tax, but there were no use word eligible. So after revenue did not allege that transaction was not bona fide, transaction was not genuine, High Court said it's not job of the buyer to ensure supplier pays tax. But remember, उस टाइम जो हमारा को जीएसटी का ऑटोमेशन था, उस टाइम दिल्ली वैट में नहीं था. Commissioner Delhi went to Supreme Court. I was a part of this SLP when we drafted. आर के वर्मा साहब थे, हमने इसको ड्राफ्टिंग की थी. Supreme Court quashed, कहते no, Delhi High Court judgment is correct. If supplier doesn't pay tax, where the buyer proves he has paid tax to the supplier, as you are not doubting any transaction, you are not saying there was collusion or connivance or there was improper things done, then there was another case of Supreme Court in Chulilal Prashadi Lal. This was a question of fake UP forms. Supreme Court said you cannot deny benefit unless you say the transactions were fuzzy. These were the words used by Supreme Court. Or there was a collusion or there was a fraud committed. From these judgments they have brought in section 74. The other judgment came, which we will discuss in detail. First was Ecom Gill. If we agree that 2(1) or 3(b) are very relevant judgment, then Ecom Gill judgment should be thrown in the dustbin. They say we don't care about your tax invoices, we don't care about your eBay bills, we don't care your payments. Prove beyond reasonable doubt that you physically received the goods that you bought for the purpose of your business or in the course of other business. Do proof. Still you have to prove. You want to know a service example? जिंदल स्टील की एक यूएस में कंपनी है, लिस्टेड कंपनी है न्यूयॉर्क में. उनको एक सुशील वर्मा ने बिल दिया 6.5 करोड़ रुपए का फॉर रेंडरिंग सर्विसेज. रिफंड मांगा. पिछला भी बिल फेक था, अगला भी फेक था, तो दिल्ली डिपार्टमेंट से रिफंड मांगा. अनंत वाड़ी मेरे दोस्त थे, अभी नाउ इज रीइंस्टेटेड आफ्टर एक्साइज केस. उन्होंने मुझे बुलाया, कहते ये क्या है? मैं दे दो रिफंड यार, एक्सपोर्टर सर्विस अलाउड है, पेमेंट आई हुई है, डॉलर में पेमेंट भी आई हुई है. कहता है देना नहीं. मैं इसको बुला ले, फिर जितने सर्विस दी उसको समन कर लिएगा सेक्शन 70 में. जब वो समन किया गया, वो एक लड़का था जो 12वीं फेल था. He was giving consultancy on packaging of containers. जहां तक भी ठीक था, दे सकता है. There's no qualification required for giving plastic packaging consultancy. बोला कहां दी थी आपने? ये 3 महीने में आपने 6.25 करोड़ रुपए चार्ज किए, कहां दी थी? तुगलकाबाद में की थी, बॉम्बे में की थी, कहां की थी? You had no answer. That is the basic transaction was posted services. बिल न्यू कंपनी में रेस था, उनकी एक्सेप्टेंस थी, पेमेंट दिया उन्होंने, तो इट वाज प्योर ए हवाला ट्रांजैक्शन. एंड दैट फेलो नेवर वेंट इन अपील. द लॉट ऑफ मनी, इट वाज ऑलमोस्ट 40-50 लाख रुपीस आईटीसी जो भी था. फिर जिनके उसका बाद आईटीसी के बिल थे, उनकी इंक्वायरी की गई, सब कुछ बोगस था. तो जितनी बोगस बिलिंग सर्विसेज में है, गुड्स में नहीं है. Right? Therefore, when you read Ecom Gill, this deals with goods. They also mention services. So, Ecom Gill judgment came, it is for or against the dealer. It's against the dealer that when you cannot prove that goods were physically received beyond reasonable doubt, आपको prove करना.
Sir, क्या उसका एक litmus test क्या हो सकता है beyond doubt?
वो सर ओपिनियन लो, पैसे तो बताएंगे, यहाँ तो ना बताऊंगा आपको. कमाल कर रहे हो यार, सब कुछ ना बता दूंगा आपको, मैं इतना कुछ बता रहा हूँ. वो एग्जाम्पल देता है, वो एग्जाम्पल थोड़ा बाद में इसको कर ले. अब ईकॉम गिल में क्या हुआ? बहुत सारी रिट्रेक्शन. आंध्र प्रदेश हाईकोर्ट ने बोला कि भाई क्यों नहीं दे रहे भाई, सब कुछ इसने कर दिया, और क्या चाहिए आपको? एक्शन वायस है, ईबे बिल है, माल आया गया है, सब कुछ उसकी किताबों में एंट्री है, सब कुछ है, पर रेवेन्यू से ये बंदा चोर है. वो सुप्रीम कोर्ट चले. सुप्रीम कोर्ट ने बोला कि दिल्ली हाई कोर्ट की जजमेंट थी क्वेस्ट मार्केटिंग, allowing input as credit under the similar circumstances, and SLP were dismissed by Supreme Court. When SLP is dismissed, Supreme Court doesn't lay down any law. SLP is special leave to petition to appeal. They say we don't allow, dismiss. So there is no law. Delhi High Court judgment was final. The Supreme Court in Ecom Gill, judges, judgment of 3 judges, they said we don't agree with quest marketing. Because like Karnataka, there was section 70 VAT Act, which says onus is upon the buyer to prove he is entitled to input tax credit. Based on same judgment, we say we have a section 155 in Delhi GST Act. So Ecom Gill become relevant if you can prove by whatever litmus test Mr. KP Singh says, there can be no litmus. It will vary from goods to goods. If you are a manufacturer, it's easy to prove. If you are an importer or exporter, it's easy to prove. But if you are a trader, it's very difficult to prove. If you are buying the same goods from many companies, it's very difficult to prove. So what good did you receive? आप कई लोग कहते हैं हम वीडियो बनाएंगे, वीडियो मेकिंग इज गोज अगेंस्ट यू. Either you have business practice, make video for all the transactions. You can't say कि सुशील वर्मा का है ना, उसका वीडियो बना के रखो, चोरी की है हमने, इसका वीडियो बना के रखो यार, यार खुद भी चोर है, हम भी इससे चोरी कर रहे हैं, मजे कर रहे हैं.
उसका हो सकता है कि अगर आपके इन्वेंटरी में उसकी एंट्री, आप इन्वेंटरी मेंटेन करते हैं आइटम वाइज, अगर उसमें एंट्री हो तो
होगी सर. सर सर्कुलर ट्रेडिंग में सब कुछ होता है, सर्कुलर ट्रेडिंग में तो सब कुछ होता है सर. ये तो मास्टर है सर्कुलर ट्रेडिंग का, जितने केस करता है वो सर्कुलर ट्रेडिंग है. एनीवे कभी से उसमें हम डिस्कस नहीं कर सकते ना, सबके अपने अपने व्यूज हैं. सो Ecom Gill, इफ यू प्रूव इट, इट हेल्प्स यू. इफ यू कांट प्रूव, इट हेल्प्स रेवेन्यू. सो Ecom Gill operates only when your physical receipt is questioned. Your IT is denied on this ground. Here Arise India is irrelevant. You have relevancy only of Ecom Gill. After this came judgment of Shanti, Kiran, again under VAT Act from Delhi High Court, on my friend Dinesh, who is no more. We had discussed this case when it was filed. Shanti Kiran says that simply you cancel registration certificates of dealers retrospectively. Can ITC be denied? हम सिर्फ ये पढ़ते हैं जजमेंट में, बस ये जजमेंट का 2% है. 98% is when High Court gave findings. Their transactions have not been doubted. Their transactions have not been fraudulent. Their transactions have been held to be bona fide. Based on this theory, they gave a judgment that simply you are cancelling RC of a dealer retrospectively. उसके ट्रांजैक्शन 4 साल पहले हुए थे, तो कोई बंदा जिंदा था, अब आप कैंसिल कर रहे हो. बट सपोजिंग यू गो रिवर्स, you say your transactions were fake, these dealers never existed. Shanti Kiran not applicable. It's applicable on the factual matrix of that case. उसमें लिखा है if you say fraudulent collusion not relevant. Ecom bill में भी यही लिखा है. If revenue doubts the transaction, the assessing officer can reject input as credit. Ecom bill में 4 पैरा लिखा हुआ इसके ऊपर. If it doubts, और डाउट का क्या मतलब हमें नहीं पता. कुछ एविडेंस रिकॉर्ड पे लाएगा, सर्वे रिपोर्ट है, इंस्पेक्टर को भेजा, उसका बैंक देखा, ये देखा, वो देखा, कुछ भी करके वो लाएगा. तो उस जजमेंट में भी लिखा कि अगर आपकी ट्रांजैक्शन डाउटफुल है तो असेसिंग ऑफिसर कैन रिजेक्ट इनपुट एज क्रेडिट. तो शांति किरण ऑपरेटेड इफ यू आर, दैट्स व्हाट आई से, व्हेन यू गेट दी 74 केसेस डन, डोंट जंप के उसने आपका केस कर दिया. कमिश्नर हैज फर्दर 5 years to supervise it. 5 साल अभी उसके पास और भी है ना कि मेरे विल यू गो. तो उसमें ये सारी फाइंडिंग आपको लिखवानी चाहिए कि आई हैव एग्जामिन्ड ट्रांजैक्शन आर जेन्युइन, आई हैव सीन द डॉक्यूमेंट. ये इस तरह फाइंडिंग हो तो कमिश्नर के लिए बड़ा मुश्किल है उस फाइंडिंग को रिवर्स करना. इवन द ट्रिब्यूनल कैन नॉट रिवर्स ए बोना फाइड फाइंडिंग अनलेस वी मेक एन एप्लीकेशन. ये फाइंडिंग परवर्स है, नीचे अफसर ने रेपेरी की. तो शांति किरण की एप्लीकेबिलिटी सिर्फ इस इश्यू पर है. इससे पहले जजमेंट सुप्रीम कोर्ट की स्टेट ऑफ महाराष्ट्र वर्सेस फ्रेश ट्रेडिंग कंपनी, where the C form was cancelled retrospectively, though under section 8 of CST Act there was no such power. But Supreme Court said notwithstanding with the power or no power, C form was given for the transaction done 5 years ago. He cannot be denied a benefit unless again the transactions were in collusion. Then we came to Shanti Kiran. We said RC cancellation. Shanti Kiran is a 4-page judgment. It's not an actual judgment. They have just endorsed the theory of Delhi High Court. In Shanti Kiran, Ecom Gill was not discussed. That's a beauty. Shanti Kiran is a much later judgment than Ecom Gill. So neither the appellant counsel, petitioner, nor the government advocate brought Ecom Gill. Had Ecom Gill been brought, Shanti Kiran would not have seen the light of the day. It's my view.